It should be listed in item number. For that matter. Okay. You take it own way.
Still matter is the training order. They are mentioning for tomorrow. Similar prayer.
Item? Yes. Huh?
Yes. Because it is still a case of condition. The government has also said that. Only person we can regarding the lack of this.
Where, what do you want? Huh? It was Ampara.
Yes. And for the respondent number 2.
Yes, what is it?
The petitioner wants it to settle into mediation.
Item number 29.
29.
It has been submitted at the bar by the learned counsels appearing on behalf of both the parties, that taking into account the workmen in question have already crossed the age of superannuation, the question of reinstatement of the workmen does not arise. The only issue, therefore, live issue which remains to be adjudicated is the entitlement of the workmen to the back wages. It is also submitted by both the councils appearing on behalf of the parties that they would like to explore the avenue of mediation, taking into account the said submission, list the matter on 17th of March 2026. In the meantime, the registry of this court is directed to allocate a mediator for allocate a mediator to settle this, to mediate amongst the parties in respect to the live issue, and then submit a report before this court on or before the next date.
They make the report. W.1
Give your name in the slip, everything will be mentioned.
May it please your lordship, with the consent of the other side, I beg to mention item 22, lordship. It is listed at 2 p.m. today and it is fixed for final disposal. But I'm constrained to seek an adjournment because I'm stuck in Delhi. I could not get flight tickets to come back to Guwahati yesterday and today. I tried both. Lordship may give a short accommodation maybe on Friday, or if lordship permits on Monday or Tuesday, if lordship can
Who is appearing for the other side?
Lordship, I have actually taken an consent on the consent adjournment form. I've taken a consent from them.
Because I'm not going to have it before vacation.
Yes, Lordship. Lordship may keep it right after the vacation. And Lordship, actually, it would be fair if I appear online. Physically, it had been better, Your Lordship. It's a crucial matter.
Ms. P. Borua, the learned counsel appearing on behalf of the respondent numbers 2 to 5, 6 for an accommodation. The counsel appearing on behalf of the petitioner has no objection. Consequently, matter to be listed after vacations.
Obliged, your lordship. Much obliged, your lordship.
For addition item 1 and 2. Section 13. That is so. I think it's not one reflection. Reflection, your lordship. There was listed on last part of this month. And keep on tomorrow is, but better just not come up.
Tomorrow it has not come up. I have fixed it.
Yes, 110. 110.
Today is 9th. If it doesn't comes up tomorrow, tell the registry that the matter is fixed. And if it doesn't comes up, we'll take it up tomorrow. Don't worry, you don't need to mention about that matter. Item 1 and 2, I will take it after vacation. Not now. You have lost the bus. I'm releasing it from Pathard. Item 1 and 2 to be listed. Huh? Oh, why means you, on the last occasion when I was about to dictate and complete, somebody of you have filed an additional affidavit and all these things. So therefore, no. You see, no, Madam, the question doesn't arise in that regard. I have half dictated, then you come up with all these things.
Oh, my lord,
No,
not in my case, not case only.
can't help it.
Item number 2, I have not disturbed your action.
Oh, I'm not having it now. Please the matter release for Pathard. Next.
Item 3 to.
We'll have it
17.
after vacations, a date. You want a date?
Next,
No, next week not possible.
some other already may not be from 2017, they are fighting. Once it was allowed. But they have, instead of complying the order, they have passed the speaking order. Then the second time I have come. So, it will be good for 10 years.
The first time it was not allowed. It was sent to their authorities to look into it, and that resulted in passing.
Text by the board.
I also had a positive view, but on the date it was done like that. Anyways, I'm busy in other matters. I'll help it now.
And from my side, my lord, I have not submitted it.
Okay, we do one thing. I'll do one thing. I will detag your matter from the other matter, and I'll take your matter immediately after vacation.
Someone in New Year. New Year,
Yes.
26. It will be kept as pilot. My letter will be kept as pilot. That has been the law. They've been segregated because I have not disturbed your lordship by finding this or that. Then tell me, gentlemen.
Now, taking into account that an additional affidavit has been filed in WPC number, here, item number 1. Pursuant to the hearing being completed comma, this court therefore detags item number 1 from item number 2, writ petition to DDM. First, as the hearing in respect to first, under such circumstances, comma, this WPC number icon number 22 be shown as Pathard and would be further taken up for hearing on 6th of January 2026. Mr. B. Uwe, the learned counsel appearing on behalf of the Industries and Commerce Department,
Sir.
who appears on behalf of as the additional AG, shall ensure that the records in respect to WPC number, item number 2, Zunkhari, are available on the next date. Econ Divo, next petition, item number 1. List the matter release from Pata to be listed in the usual course.
My matter will be listed.
Yours is item 2. Item 2, I have kept it. I will hear it on 6th. Whereas item number 1, I'm releasing it to be listed in the usual course. Sorry, I can't help you. Why on earth did you file an additional affidavit? Didn't I complete half of my dictation in that matter? Then, if you have filed that additional affidavit, then which means that you don't want this court to deal with your matter. You shouldn't have filed that. Release here to be listed in the usual course. Yes, let us hear item number 3 onwards.
217.
Hey, my dictation issue. Motor Vehicles Act and Motor Vehicles Act are rules continue. You got rules are technical. Has anybody given me that Gohar Mohammed judgment? Where it was gone? Every time everybody is giving me, they're not getting it. Got it. Yes. Yes, what is your submission? How do you take care of that 29 on the issue pertaining to? I was on the last occasion in the judgment of the year, this was observed at this juncture, this court finds it relevant to take note of section 159. Yes, what do you want to say? How do you, means 166.3. I'll hear you, Mr. Gusam. 166.3. Earlier, as per the 1939 Act, 1939 Act, there was a provision of condonation of delay.
Yes.
If filed beyond the period of 1 year.
And if I'm not wrong, section 110, 1K, subsection 3. In 6 months, it had to be filed.
And beyond that, there was a power to condone.
Or
Show me that provision.
then there is
Here, you see, no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. That was, which is 166.3, same word, but there is a proviso. Provided that the claim tribunal may entertain the application after the expiry of the period if it is satisfied that the applicant was prevented by sufficient cause from making such an application. Now, 89 also, same provision. But it put an embargo that it cannot go beyond 12 months. Then there was another amendment in 1994, whereby it took away 166(3). Now 166(3) has been brought in. Now the word out there is no application for such compensation shall be entertained unless it is made within 6 months of the occurrence of the event. Now, this is the same wording
Same like that.
in 166(3) as we have it now. But earlier, this provision what was subsection 4 earlier?
Hold on. I think
Prior to this, you see, subsection 4 have been amended also by the 2019 Act.
this one, 4 by the, for an environment, I don't have the full file right now, sorry, Miller. Well, the, any accident person before, the next step in the gap, we did an application. 166 subsection.
Earlier,
Earlier.
but there was no similar provision like 159.
158.6 was there. 158.6. That has been dealt in this, has been met, 158.6. Because, there is another judgment from our High Court also. That is, like say number versus state of Assam. That in that case, 158.6 was directed to be enforced. Because in that case also, police report was not coming. 158.6.
This is 158(6). Now, what did the Supreme Court do in this matter with the certified copy, the copy which you have given us?
What different, actual part is different one. Because, the accident took place by the amendment of 1990.
That is also, our High Court also held in another case.
Because the accident took place by amendment and amendment.
Prior to amendment coming into effect.
Yes. And that amendment was not not retrospective in nature. That is why the application was allowed. The actual part is somewhat different level.
Okay, now how do you tackle the situation with section 29(1)?
So far my knowledge and my understanding goes by the, because section 160, subsection 3 by the. Of course, there is no proviso that the penetration shall be entered in after the 606 months. And section 3, then it will be applicable, section 3 of the Immigration Act. But the section 4 to 24 prescribes the exception to subsection 3 method. Now, if you read section 29, subsection 2 method, the part B.
Hey, limitation activities. Limitation. Yes, what does it say?
Part B method,
Yes, tell me.
and for the purpose of determining any period of limitation prescribed for any suit, appeal or application, this is claim application, by any special or local law, the provisions contained in section 4 to 24 into 6 shall apply only insofar as and to the extent to which they are not expressly excluded by special law or local law. So for my section 1, section 3 is concerned, here, my lord, the provisions of section 4 to 24 is not specifically excluded. Section subsection 3 my lord. But my lord, I have come across a judgment my lord, wherein it is stated that my lord, in relation to West Bengal Land Reform Act, section 8. I read the 11th portion, my lord. Because why am I referring to the judgment, my lord? Because in case of MSC appeal, the section 173, there is a proviso of section 5 of the Elimination Act. Can extend the time limit of 90 days.
So therefore, you mean to say, when the statute in a particular provision have given the application of the Limitation Act, and in a provision have not given, it is impliedly excluded. There's one judgment, very beautiful judgment on that, some starting with Mary something, I forgot. It's a beautiful judgment on this very aspect. Anyway, I get your point on that.
Also, I am relying on the judgment of Gopal Sadar versus Karuna Sadar. That is in relation to West Bengal Land Reform Act, section 8. So I read the 11th portion only. We conclude that section 5 of the Limitation Act cannot be placed into service in aid of a belated application made under section 8 of the Act in continuation of delay. The right of preemption conferred under section 8 is a statutory right besides being weak. It has to be exercised strictly in terms of the said section, and consideration of equity has no place. On the facts found in these appeals, applications under section 8 were not made in 4 months from the date of transfer, but they were made 4 years and 6 years after the date of transfer respectively, which were hopelessly barred by time. Benefit of section 5 of the Limitation Act not being available to the application made under section 8. Section 3 of the Limitation Act necessarily entails their dismissal.
But what is the wording of section 8?
Section 8, my lord, of Bangalore, then of
No, it must be there. What is how does section 8 read?
Section 8, my lord. Yes. If a portion of share of a plot of land or a riot is transferred to any person other than a co-sharer or riot in the plot of land, the burdener in the plot of land may, in 3 months of the date of such transfer of any co-sharer of a riot in the plot of land, may, within 3 months of the service of notice given under subsection 5 of section 5, or any riot possession land adjoining such plot of land, may, within 4 months of the date of transfer, apply to munship having territorial jurisdiction for transfer of the same portion or share of the plot of land to him, subject to the limit mentioned in section 14M, on deposit of consideration money together with a further sum of 10% of that amount. Here, my lord,
So therefore, there is a right of filing,
I don't find.
but it is not curbing the right to entertain. You see, last day, when I was taking up the matter, section 3 is what? Section 3 is that no application, suit, appeal, or application can be filed for the purpose of beyond the period stipulated in the schedule. That's section 3. And if it is filed, it will be dismissed. Isn't that their language? So therefore, the right is upon the claimant to file, not an embargo upon the court to entertain. Just for example, can I today take a suit, a money suit? Can I take it? I don't have the jurisdiction. I don't have the power to entertain a suit. Taking into account the Bengal Agra Civil Courts Act, Assam Civil Courts Act, empowers the district judge to entertain a suit of a civil nature. So therefore, there is no power conferred upon the High Court. Now tomorrow, therefore, I can't entertain the suit. The power is given to file or right to file is there. Now, tell me, if a suit is being filed, let us see the registry today passes it and brings it before me. Or let us take a more better example. In a Patents Act, when a suit is being filed, it goes before the district judge. This person concerned files the suit here. And it comes before me, taking it to be a commercial because I have the commercial jurisdiction. So it comes with me. Can I entertain it? Can I even entertain an application for condonation of delay? Suit to condonation of delay doesn't arise, but then also, can I entertain that? My question is that the power to entertain is different from the power right to file. The right to file is a right which is being given to the litigant or a claimant to come and approach the court. But the court's power statutorily is being taken away, saying that beyond 6 months you cannot entertain. If you see the earlier language of 110(3), it says, provided the court can still entertain. This is a power being given by the statute. We don't have the power, neither by a court order you can create a jurisdiction or take away a jurisdiction. The jurisdiction is on the basis of the law, and the law is the statute. So the power beyond 6 months of the accident is not given to the MHA.
But the language also, is also in the form negative kind of, no application for corporation. So my humble understanding is that there is no scope for other interpretation and to dismiss it if it is filed beyond 6 months. As per the
No,
language
dismissing is another aspect. Dismissing also involves, in a pure sense, dismissing involves a exercise of jurisdiction. So what you would need to do is you cannot entertain. And the proper word, if I may use it, would be reject.
I'm not government, entertaining the application, that is to see the made of the case also. Constantly made of the case also.
So you can't dismiss it, you have to reject it.
Reject.
Yes, Mr. Borbujari, what do you say?
One aspect of the matter, I was reading the notice of this honorable, and I was searching, I have come across a recent Supreme Court dictum. My lord, this in Navaneka, maybe lord, it is aware, where my lord.
I'm aware with that, but tell me, the problem arises there is this. With due respect, the Supreme Court did not stay the provision.
In the provision, but the apex court says, my lord, that the high courts and the tribunals, language is there, my lord, it is made clear that during the pendency of these petitions, the tribunal or the high court shall not dismiss the plain petition on the ground of such petitions as barred by limitation as prescribed under subsection section 3 or section 63 of the Motor Vehicle Act. Only to that limited extent.
No, understood. Shall not dismiss it, but keep it pending. Meaning thereby, what is the consequence? Today, the interest, if the claim is allowed tomorrow, means you are putting the claim out there at hold.
Something is kept in abeyance.
You just keep it, you entertain it, but don't dismiss it.
Yes.
But you can't proceed.
Yes.
The court, with due respect, ought to have said that you can proceed with it. Ought to have stayed 166(3), which the Supreme Court does have the power to do.
Meaning thereby that the lease is still alive.
The least power to entertain is not given. What is being done is don't dismiss.
Yes.
The wording is don't dismiss. So if you don't dismiss, means you just keep it as it is.
Now, confronted with the present situation.
Now, but you have to also understand, I asked you to assist the court on that day. Here is the case. In some cases, it has been dismissed. In some cases, the court exercised powers under Section 5 and held that there was sufficient cause. And that is why the insurance companies are before me. So the jurisdiction which I am exercising is 227, whereby this court cannot touch on 166(3). It has to take it as 166(3) exists. Either this court can very well say that, look here, in view of the Supreme Court's matter, let us keep this matter all along. But would that equity demand tomorrow, if there is a delay in disposal of the claim applications and certain amounts are being awarded, it will accrue interest? That is the law. Now, on one hand, it's a welfare legislation or beneficial legislation, the claimant can get it, there's no quarrel with that proposition. And the claimant also needs an urgency. The damages which is being given is an urgent sort of nature, that you kindly take over or get the benefits of whatever the compensation. That is why all these amendments happen. So therefore, this court has to dispose of. I can't wait for the order of the Supreme Court. Yes, tomorrow 166(3) is held to be ultra vires the Constitution. It's a different thing. No, that day Madam also placed that. I'm aware of that, but that is the issue. How I will take care of it, I'll pass the judgment in that. But the only issue is I have to deal with these judgments. All the insurance companies have come whereby Section 5 has been taken. Now you see, there is a judgment of the Karnataka High Court which permits the using of the Section 5 as a recourse, which I don't agree. Of the limitation.
166(3).
For the Limitation Act.
Yes.
Which I don't agree, taking into account that if you don't have the power to entertain
Yes.
by the statute, how can you entertain an application under Section 5 also? On the other hand, if you see 166(3) and 166(4), 166(4) says that any report given under 159 would become so and so, would be treated as a claim application. Meaning thereby, irrespective of 166(3), if there is an accident, an obligation is casted on the 159 upon that particular officer to submit a report to the court as well as to the insurance parties and all. So on the basis of that, if he submits the report, then the court has to take it as a proceedings under 166.
Meaning that it is akin to 166.
It becomes 166. So therefore, you cannot read 166(3). Yes, only thing which I find the difference is, if you don't file an application under 166(3), you lose on the territorial jurisdiction.
That may be, yes.
That is the only difference which is there.
Yes.
Because 166(4) will be only before the court, wherein the officer in charge or the investigating officer would submit the report under 159. And there you can file an application, you will be treated to file affidavit. What is the recourse is, you can file very much affidavits. So once you file those affidavits, then it will be treated as a claim proceedings and proceeded. The only thing is, without 166(3), if you don't file it, you cannot later on say that, okay, get me out there in Guwahati. I have the better lawyers in Guwahati to prove it. That can't happen. Now,
There also the time is 3 months. 3 months time, the police officer, they can 3 months.
if he doesn't do, it is obligatory. That is why we have got that notification issued, where disciplinary proceedings are there. If they don't give it within 3 months also, it can be kept it. It is otherwise the mandate of the court also, as per the rules also. It is the mandate. So that is what I am passing. And if you see Gohar Mohammed, there are strict directions being given under paragraph 64 and 65. And this is for which that particular notification has been issued by the state government. So therefore, that will take care of it. So there is no time limit for them. When it is a duty cast upon the state, they cannot later on say that within 3 months we have to file, we have not filed, forget it.
On that. When they did not take up the honorable court passed the judgment that it will be the liability of the state and the police officers.
No, I have passed in this batch also. I passed an order where everything has been submitted. This is just for the purpose of regularizing that very aspect for which we got a notification passed. The reason why the notification had to be passed is, again, now if you see section of 170, not 170, 178, 176. Carrying into effect the provisions of section 165 to 174, and in particular such rules may provide any following the form of application for claim compensation, particulars, the procedure to be followed by the claims tribunal in here. Now, whether the state has made any rules? Yes, state government. No, after this. Because now after this, you have to amend. Where is Mr. Deenath? No, this is by the state. Center has already done in terms with section 150. And thereby incorporated Annexure 13. 150 right of the state to make the rules here. Center is where? 164C, I suppose. 164C is that one. Power of the central government to make rules. So in terms with that, they have already made the rules. Amended it, brought in Annexure 13. Now the state have to make the rules. Have they made the rules? Because UP and everybody has made the rules. Yes. Have you made any rules?
After 1911,
No, you have not made the rules. I don't think so. You have made the rules. Now, you see, UP has made rules. UP, Bangalore, and all these things, the Karnataka have made rules, and many other states have made rules pursuant to this, which the state is also obligated to do so. Now, if the rules are not made, this court has to pass certain orders that this is the procedure to be followed till the rules are made. Because 176B 176B says the procedure to be followed by claims tribunal in holding an inquiry under this chapter. So this is the chapter under 166. So unless they frame the rules, they should have framed the rules, which they have not. Now in UP, they have made these rules. It's a very interesting rule. Kindly see Rule 204A, by which they amended the UP motor vehicle rules. Have a look at this. I think we can incorporate this aspect. Till you frame the rules. This 204. Now here there is a very interesting provision. If somebody, the moment an 159 report is made, the tribunal then would issue notice to legal representatives or victims, insurer, everybody. And asking the legal representative or the victim as to whether you have filed any claim petition. If we have filed any claim petition, this FAR or the DAR, as the case may be, R or DAR, as the case may be, would be tagged along with that particular claim petition. Now we have a High Court notification whereby it is being given, if I am not wrong, the High Court is notification. In fact, in my opinion, the High Court could not have issued that notification on but on an administrative side, they have done under 235, it's a different aspect, or 227, they have done it. But the fact is, it is the state who have been empowered under 176B to do it. They should have done it. Anyway, that is beside the point. Now, another very interesting about this rule is, if they say the claim petition is there, it will be tagged. If the claim petition is not there, they will be asked to file an affidavit and proceed with the claim proceedings as if they have filed the claim proceedings. So it takes care of not filing under 166(3). The next course is, if they say, if notice is being issued and they don't file, you need a closure also. How do you close it? The closure is being given there. If you see 204A(C), you read it for the convenience of Mr. R. Goswami.
Section 2004A. The police report submitted under section 158E, 158(6)(1). On receipt of report of investigating police officer submitted under Rule 4 of Rule 202A, the claim tribunal shall go through the same and make call for such further information or material as considered necessary for effective action in accordance with subsection 4 of section 166. 2. The claims tribunal, after examining the report and further information materials, if called for, shall register the claim case thereof and then issue notice for appearance to all the parties concerned, which would include the victims, the accident of the legal representative of persons deceased, as the case may be, driver, owner, and insurer of the vehicle involved in the accident. On receipt of notice, the parties mentioned in Rule 2 would be required to appear and declare through affidavits, if any, claim case has been preferred or was being preferred in respect of the same cause of action, and if so, the report of investigating police officer prepared as claim case would be tagged to such case preferred independently by the parties.
So therefore it will be tagged. So if they tomorrow say that, look here, I prefer the claim petition at Guwahati, accident happens in Dhemaji, so it will then be tagged.
If the person injured or legal representative of the person's deceased do not appear in response to the notice issued under subgroup 2, in the matter indicated in the subgroup 3, the claims tribunal may presume that the said parties were not interested in pursuing the same for any competition in such proceedings, and on such presumption the case shall be closed.
So the claim tribunal shall close it. Then, because you need a closer somewhere.
Yes.
If somebody doesn't come, you can't keep a matter pending for all times. Otherwise, it will again go after 10 years. If somebody comes and reopens, that cannot happen. You can't keep that pending for all times.
Now the police reports that will be.
Yes. So therefore, then you see the next
So,
one.
unless the police report treated as claim case stands fake to the independent claim case preferred by the parties themselves, the claims tribunal shall call upon the persons injured or legal representative of the person deceased, as the case may be, and the persons who have appeared in response to the notice to submit statements of facts regarding compensation if claimed by them. If statements of facts about compensation claim and basis thereof are furnished by the parties, the case shall further be proceeded in this same manner as required to deal with applications moved by the parties for compensation directly before the claims.
So therefore, it will then take the flavor of a 166(3). So the limitation, therefore, taking away the limitation, in my opinion, is for the purpose of giving an more urgency into this, and thereby certain embargoes have also been put. Now they also mention about another section by which a duty has been cast under 159. Shall during the investigation prepare a report. So 159 gives that power. Then you see, and again under 149. So the moment the insured, because now you see there are duties which is being cast. Now here in this case, the Allahabad High Court, while dealing with it, observed that as this particular procedure was not followed, so therefore directed the claim tribunal to follow it. But the Karnataka judgment, although brings in section 5, you have it?
Yeah.
Yeah, I know. By Justice Suraj Govindraj. Huh? Yeah, because I have a problem in this observation. Because when you don't have the power to entertain, how are you going to entertain a section 5?
So here the ultimately the case as observed in this case is that this is a beneficial legislation. That in that.
Now, beneficial or non-beneficial, when the power is not there, tomorrow if there is a beneficial in the name of legislation being beneficial, can you do violence to the statute?
But,
You will have far-reaching consequences.
there are 11 onwards.
It seems the court was more swayed with the fact that they filed writ petitions against the tribunal orders. Isn't it? No, I am on another aspect. If you see the judgment of Karnataka High Court, wherein also section 5 has been brought in, is another judgment of Justice Suraj Govindraj. Now, in this judgment, very important directions were passed. The directions were, which I think may be relevant, is here, this one. There were directions given for integration of the state police IT to integrate the police IT system with the integrated road accident data based e-detail accident. On the Parivahan website. These were the various directions which were passed. Now, here also, if we can issue that directions, thereby asking for integration of this, integration, and that website is also to that extent is available to the insurance companies. That would also, the moment you are entering the data, they will come to know under 149. Because you see the words used in 149 is on the basis of information by the claimant, on the basis of information by the police, or otherwise. So this information, if it is seen, kindly see these directions. Ekhan Gutiya. (25)(1) onwards.
All of them are required to implement the central motor vehicles and under rules of 2022. The police IT is likely to integrate the police IT system with integrated road accident database. E-detail accident for EDAR on the Parivahan website set up by the Ministry of Road Transport and Highways. The police IT is also directed to integrate with updated disability ID website set up by the Department of Empowerment of Persons with Disability of Ministry of Social Justice and Employment, Government of India, in order to track the disability caused to a victim of accident and the report issued by medical board constituted under the Disability Act. The police IT to integrate the forest laboratory management system set up under the state of Karnataka as also with the Vahan website. The police IT to integrate with all the insurance companies providing insurance service in the country so as to secure the details of the insurance policy in respect of the vehicles involved with the accident on the basis of vehicle number. The police IT will integrate with the transport department so as to secure the details of the vehicle owner and the driver involved in the accident. All the above details to be made available to the courts by integrating with the case information system used by
So they are therefore integrating with the CIS.
CIS.
With the CIS, immediately the court will also come to know. So the filing out there by submitting manual copies on all these things are being done away with on the basis of these.
This will expedite the
I'm yet to get a confirmation whether this was done or not, because this is an order of 2023. 2023 order, and this matter was kept pending. If you see the last line, last paragraph, this is the matter after 4 weeks.
Yes.
For an update.
I have found one well, is discussing 160 and also 29 the limitation.
This is given by
Kerala. Let me kindly see paragraph 84. Well, here also my lord, the claim was filed after the 6 months and then the schedule. I think the 166 street.
Uh, Tell me another aspect. Reading this judgment, you'll get an idea. What happens? Just for example, a person is lying in the footpath, he dies. Nobody knows. Accident report being submitted. No person to be given notice. After 2 years, they come to know. How do you take care of a situation then? How do you take care of a situation?
That is the method. That is the method, the reinstated method. New rule. That is the method to draft the situation of the new rule for the section, the rule 150A method.
158. 158, yes.
Of course, there has to be an intimation of the accident method.
Ah.
But immediately on receipt of the information of a road accident, the investigating officer of the police shall inspect the site of the accident. Take
Where
photograph.
150?
Rule 150A, the motor vehicle rules.
The procedure to be followed for investigation of all accidents arising out of the years shall be in accordance with 13 and in the manners of submission of form, including electronic submission on such portal as may be specified. That is 150A.
150A, 150.
This is what it is. You are reading an old act.
No, the new motor vehicle rules. Rules.
When was it brought in? New one.
New 1422 method.
No, so that is what I'm reading. 150A. The procedure to be followed for investigation of all accidents arising out of the use of motor vehicles shall be in accordance with Annexure Roman 13 and in the manner of submission and forms, including electronic submission on such portal as may be specified.
Annexure 13 method.
Annexure 13 you are referring to. So then refer to Annexure. Yes, tell me. Which one?
First one.
Ah.
Immediately on receipt of information of a road accident, the investigating officer of police shall inspect the site of accident, take photographs, videos of scene of the accident and the vehicles involved in the accident, and prepare a site plan drawn to scale as to indicate the layout and width, etc. of the road or places as the case may be, the position of vehicles and the persons involved, and thus other facts as may be relevant. In injury cases, the investigating officer shall also take photographs of the injured in the hospital. The investigating officer shall conduct spot inquiry by examining eyewitnesses, bystanders.
Bystanders and the eyewitnesses will be nearby. That is what they are. I'm asking about the situation where a person is lying in the footpath, maybe drunk. He's lying in the footpath. He doesn't have his wallet, nothing. Even the other card is not there. Some car comes and bashes him. Or think about in the highway. A person is standing in the highway, somebody bashes him up with a big truck. He dies. Nobody knows.
If it is so, I don't.
Then how do you take care later on,
Can run.
after investigation, which may go for more than 6 or 7 months, if it is, comes to light that this particular person has died and the claimant, because till 7 years nothing happens, he may keep a statutory period is there. So therefore, these people were also searching that he must have been kidnapped or something must have happened. And later on, after 6 months, he comes to know that this person has died out of a road accident which happened after 1 year or 2 months, 2 years. This is the investigation report. Then, in the meantime, the FR must have been filed without giving details as to who are the legal representatives, who are the persons concerned, that an unidentified person have died. How do you take care of a situation then?
This way, my lord, this par IR guard has to be given.
You're not getting the point. Everything is done. Let us assume everything is done. Don't you see a charge sheet wherein it says that the person concerned could not be traced out who had caused the accident? Don't you get a charge sheet? The person concerned could not be traced out. The truck could not be traced out. And as such could not happen, and as such the closure report is being submitted. Don't you see? So that might have been also the effect of a dart.
In that case, my lord, if I'm not wrong, they have to be treated as section 164. No negligence case. Because.
No, it can't be no negligence. It may be a case of gross negligence. 164 is a different thing, where he need not prove negligence. That is 164.
But what is going on in the performance judgment, my lord, itself.
Yes, Mr. Goswami, what do you say on this very aspect? How do you take care of a situation of this kind? Now, can you say therefore, 166.3, the period, if we don't bring the limitation act, yes, no doubt it is beneficial. In all other circumstances, it can be taken care of. But what happens in respect to unidentified persons?
I'm here at this corner to be.
Please.
Actually, as I see it, this is a result of legislative conflict of legislative disaster. Initially, as their lordship 110 of 1939, there was a definitive period. Then it was amended to 6 months, but not in any case beyond 12 months. Then it was altogether discontinued. Then it was that this for this chairman, my friend is right. Vinala. Here itself, this expression concern has been taken note of by the parliament. What, like the lordship said, someone discovers or recovers after 2 years, 3 years, you are in a state of coma. Someone or someone that the notice has been received by the legal years that shows the person has died in Assam. Someone from UP. So what happens then? Lordship, in order to take care of this infinite period was introduced. Then it has again been brought back to 6 months. This, as I see, is a conflict of legislative desire, whether to do or not to do, whether to dismiss it or not. But here I see it, that in this new act, there are the seeds of an application, a proxy application has already with the court, by the state government. What happens to the seed? No one claims after 2 hours, police has registered a case, passed it on to tribunal. That application is lying here, and no one comes for it. Like your lordship said, 2 years, or he may never come. There has to be some way to, it cannot be dismissed.
Now, can we do one thing?
And that lordship,
No, can we do? You see, in 204A, which Mr. Nath had read in the UP judgment, we say that till the legal representatives of the person against whom a FAR or DAR has been filed in respect to an accident, the thing cannot be closed till notices are received,
That is one,
by which it will be remain open. What do you say? If notice is issued, it is received, matter closed, and they don't come forward. If notice is not received, you cannot identify who is the legal representative. It cannot be closed. It will keep on pending. So in respect to these type of circumstances, it can be duly taken care of.
If the disease is not identified,
Hmm?
in case the person is not identified.
It may not be identified. The claimant also may not, the witness also, the legal representatives also may not know that they're somebody or near or dear ones or their, yeah, for whom they are the claimants can have died. And in the case where this, although it is obligatory, if it is not filed, then also, just for example, this in 159 is not being complied with by the police. Then what happens? The next question. How do you take care of that situation?
whether it is done it or not, the act says that it has to be done by the police. In that case, I imagine that proxy application is always there with the family.
No, if the police doesn't do, which is the case here. Now, all these other cases out here is a result of
Has
that.
not been done, that's a different situation.
Huh?
It ought to have been done, but has not been done.
Ah.
But still, it says that somehow by default, that application should be presumed to be in the track. Whether the claimant comes forward or not, that application should be there. Or should have been there.
Hmm. So this is the in furtherance with that, no?
In that, so, the Karnataka.
The Karnataka, this is in furtherance to this.
Karnataka.
So it is not that it can't be done. Because here, if you see paragraph 4 of that order,
They are the.
kindly see here, paragraph 2. Learned Additional Advocate General submits that the metric so and so is the agency engaged by the police IT to study the current deployment and approach, as also suggests the future deployment and approach in respect of the integrating the e-challan infrastructure and integration of the various database available with different stakeholders for the purpose of giving effect to the amendments made to the so and so, and also to establish digital codes or the motor vehicles making it so and so. A perusal of the said study report would indicate that approach 3, which is integration with the SCRB there database and the web service co-location and so is being indicated to me. So there is a direction for implementing. Now, if there is a failure under 159 to do so, which obviously it is the mandate, can the claimant later on suffer on an account of that? Then what power? What is the power? What is the power of the tribunal to accept the claim? Because the power is not there if we hold it at 166(3).
Like to accept the judgment, usually what he versus I will prefer. Then this question of jurisdiction to entertain is in the context of section 9E. So the same year, this is entertain. If the tribunal has the jurisdiction to entertain particular suit, It has a jurisdiction. Then it must be that jurisdiction, the power to entertain under a year. The word entertain cannot be said to be the inability to grant relief on merits, but the same relates to receiving a suit to initiate the very process of granting relief.
No, there is no problem. Once you have the power to entertain, you have the power to continue, which is there. But the power is-
There a delay, and can claim application filed before the tribunal.
But then the power is taken out by the statute. That is the problem. The statute takes away that power. The moment you have the power to entertain, you can pass many relief. There's no quarrel with them.
You have a claim in front. The state has already filed. it.
No, then there is no problem. That is
Most
being,
of the cases
that will be taken care of, Mr. Goswami. That I will take care.
99% ideal situation in 99% of the cases, the application will be there at the time.
Then there is no problem. I'm not on that. I'm saying about 0.1%,
0.1%.
where a person is identified, is not identified. No R or DAR has been filed, which is required as per law. Can the claimant then come? What is the recourse available to the claimant then? I'm only putting that question. That is a maybe very negligible. So that is for the legislature then to decide as,
Can I submit
yes,
this?
please, all are welcome.
Yes, Lordship, in our cases, these cases, Lordship, what happens is we are talking about the amendment as per section, that 3 part, that limitation. But this act itself being, as per 176, as Lordship pointed out, the power of state government to make. Till now, the state government has not made it. So at least for these petitions, Lordship, I feel that they will get the benefit of, since the rules are not there, and since 159 by the police is not sent to because their requirement is 3 months there.
No, if these people get the benefit out there, then are you supporting I know you are an insurance council. We are supporting the insurance councils here.
And
They are all insurance councils here. All these petitioners are insurance council. Only one case is against you. All others are insurance.
I'm as a court official only, I'm submitting Lordship, that this same act has given power to the state government, and till now, the state government has not made any. So for these factors, at least, I'm not submitting as.
No, madam, most probably you are not there in these batch of matters which have been taking it up from time to time. In some matters, I have already passed orders asking the SP has already submitted the DAR, and pursuant to the DAR, they have already proceeded. I have regularized those. One matter or 2 matters have kept it, and then it has now come to 14 or 15 matters. Where I kept it, where I thought that it is required to pass certain directions, taking into account that the directions passed by the Supreme Court in Gohar Mohammed and the implementation which is there, there's a little gray area which needs to be codified, or something is mentioned till it is being codified by them under 176.
They need, the state
They
government,
have not done it, so this needs to be done, because as they have not done it, we need to put that 204 something is to be brought in. That is the reason why. Otherwise, there's no problem. But in my opinion, I'm very clear to the effect that you cannot entertain a section 5 after the 6 months.
so that I also support that, I
What do
may
you
find,
feel?
but. then it's the-
Please come to that, then people will know.
What I was about to submit, but actually without some research on whether 29(2) can be attracted. Now, MP Steel Corporation, not it is MP Steel Corporation, I have gone through that subject matter. There are 31, 32, 33, more precisely, there are 33. If I may read it, madam. Here, madam, Murthy Gopalan has been relied on heavily by the apex court. Now interpreting 29(2), because the only remedy that I find that may come in rescue, the claimants would be taking a recourse under 29(2). Nothing more, nothing less. Now, a bare reading of this section would show that the special or local law described therein should prescribe for any suit, appeal or application a period of limitation different from the period prescribed by the schedule. This would necessarily mean that such special or local law would have to lay down that the suit, appeal or application to be instituted under it should be a suit, appeal or application of the nature described in the schedule. We have already held that such suits, appeals or applications as are referred to in the schedule are only to courts and not to quasi-judicial bodies or tribunals. It is clear therefore that only when a suit, appeal or application of the description in the schedule is to be filed in a court under a special or local law, that the provisions get affected. This is even made clearer by a reading of section 29(3), which might not exclude divorce and matrimonial proceedings. Then it goes to say, madam.
So here it says,
Yeah.
another different twist is that it being not, because we had the judgment of 1971 Assam. I think it came from Board of Revenue.
Yeah.
As to whether the Limitation Act would apply in the Board of Revenue, taking it to be a tribunal and not a court, because Limitation Act squarely applies only to courts. And here it is tribunals also. That is what you want to say. So therefore, you can't bring in 29(2). That is what the observation is. As it
Explicitly
is.
spell out there,
So therefore, you can't bring in section 5.
section 5. That is the difficulty. And so far as my lord, Godrej Sarali is concerned, I think.
Godrej Sarali is on a different
It is-
point.
it is very-
Here it goes into the right to maintainability and entertainability, which is also on a different aspect. Here it says that the right to entertain is a different thing, which is upon the discretion of the court. That is different. But the fact remains that the right to entertain is a right, it's not a right to entertain, it is the power to entertain.
Power, yes, when it starts the non-obstante clause.
Power
No
to.
application, no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. So no application, might not superscribed by the word unless. No application unless, so it is doubly rigid. That is the difficulty.
No, I'm on the question of power to entertain.
The power to entertain, therefore, so therefore,
However, maybe power to entertain is being taken away.
power to entertain.
And the power to entertain is a power which is conferred by a statute.
Absolutely. So there is a two point, there is a kind of that the
Unless 166(3)
Yes.
is not struck off.
Yes.
The court cannot entertain beyond 6 months,
this is what apparently
except
appears.
except to the extent of permissible under section 150A.
158 by 159, then police report.
Now 159 is there, then 150A.
Yes.
Capital A,
Yes,
then annexure 13.
yes,
This is how you do it.
yes. But unless whether the state government make a rule. then
No, the central government has already made the rule.
the government has made a rule, but-
The state government has to mandate the procedure.
But the source of power has to be found in the current legislation. This is what my lord.
The power is there, is
But
done,
we
given
don't-
under
we don't-
176.
Beyond 166(3), because we are dealing with 166(3). So from 166(3), other provisions comes out. And so far as 159 is concerned, my lord, it's a, my lord, independent exercise to be carried out. It says, my lord, for a section, my lord. 4. The claim tribunal shall treat any report of accidents forwarded to it under section 159 as an application for compensation under this act. So there may be a situation where an independent or separate application may not have been filed, but the report is there, and the report is taken to be, my lord, a claim application. Now, suppose, my lord, by the time the report comes, a claim petition also comes. It will be affected by the doctrine of merger, it merges. Now, therefore, this 159 operates on a different footing and 166(3) operates on a different footing. So therefore, if we.
No, but no, you cannot, because the moment 159 is there, 166 4 ticks without the 166(3).
Therefore, because 166 4 is a fallout of 159. It is a fallout of 159. So an exercise has to be undertaken by the authorities concerned, that is the investigation agency, that is the condition precedent.
So therefore, after Gohar Mohammad's judgment, more particularly paragraph 64 and 65, there is a notification now issued by the central state government that if those officers who do not do, they are going to take disciplinary actions. So that is one aspect that is being taken care of. So now earlier they were issuing some circulars with written letters. I asked them to put it to a notification, then it becomes a law. So now that is the law, that if you don't, then disciplinary proceedings will follow.
Of course, when on the state, say, on the removes have been jurisprudence that disciplinary proceedings will be taken.
No, one is not only disciplinary, there is a direction, that is the law from the state. The state has made it very clear, because you see, now you don't have 176 rules under 176 made by the state. So this will be an executive instruction till 176 rules are made.
Okay, fine.
And apart from that, what is given out there in 204A, which he read it, needs to be incorporated in the disorder which I propose to pass, so that till it is not being codified under 176, this shall be the regulation. I think that is how it is.
The language very hard, like notwithstanding, then unless. Two minor people on so far as entertaining it is concerned, will not say.
So the final order out here in all these cases is where a claim petition has been dismissed, we interfere with that. I interfere with that and direct if they have not submitted the DAR or R, has to be submitted. In respect to where it has been exercised, section 5 has been exercised. I hold it to be bad, but that shall be the authorities now, they shall wait for the DAR and R and thereupon proceed as a claim petition. Although there might be a delay, but this is how it is. So give me those judgments back, which I gave it to you. Anything more?
One judgment is there on 166 subsection 3, that is by Madras High Court, my lord.
What did they say?
Findings, my lord. The amendment to section 176 subsection 3 of the Motor Vehicle Act is to be implemented scrupulously, which refers to the accidents that occurred after March 2022. Because this case, my lord, relates to an accident that had taken place prior to the amendment of the Motor Vehicle Act. my lord.
No,
Then
but
they
these,
together.
this judgment does not take care of that thing.
That
That aspect is not, the only, I think the only aspect is being taken is by the Kerala High Court. Then which he submitted, then you have the Karnataka High Court.
And another judgment is there of Telangana High Court.
What does it say? Any judgment in my support, what I am submitting. Everybody,
I support that.
huh?
I support. Totally what logic.
But each judgment is
There
also
might be a judgment logic, it is not necessary.
No, no. No, therefore, there means that it will be more hard work. And you give me that judgment.
Yes, yes, that. one another aspect is in our mind. I have failed in doing so, my God. The purpose and intent of incorporating 166 entry, the legislative intent. That point has, my God, we may look into. Why that embargo has been created? 6 months. I mean, this is a very recent legislation. No.
No, it is not required. I had the experience when I'm taking bench one. After 10 years, 12 years, they are filing. And it becomes impossible for the insurance to have records,
Yes.
to have an investigation. Nothing is there. After 4-5 years, charge sheet is being submitted. And therefore, they cannot do. 4-5 years, charge sheet submitted. Then after 10 years, they file. This is creating a huge problem.
Virtually delivery method that was filed after 17 years.
17 years. 17 years they filed. I think I dismissed that, the claim petition. Now, you cannot do that. Although no time has been given in there, but then also, you see, there is a question of lapses and all. You cannot. It's something like the section 10 reference.
Right, yeah.
The prejudice being caused to the other side is another aspect which needs to be looked at.
100% not even born when his father died.
See, there are many cases. When I take bench on, yes, as Mr. Goswami submitted, a person after becoming majority, he files a petition. And at the time when his father died, he was not even born.
Correct.
And
Something like maybe section 3 of the highway.
he therefore, huh?
Application might have that completely determined. Timeline is not.
Okay, then I'll do CAV. So many things are to be written. Although I'll give it before vacations. I've done 50%. Because I have to beat. Woman, I need to deal with the judging. So Hyderabad, what does it say?
But that issue of section 5 of the Litigation Act, I got it for Honorable Kapoor was applicable, but the issue must get open for further discussion. And that judgment, very judgment was stayed by the Honorable. Then probably the judgment will.
That has been stated. No, I think this is it, and you give that judgment citation.
It is
Hearing completed, judgment reserved. Give it before.
2015 SC 58. 2015 SC 58. Paragraph 31, 32, 30.
The printer will have played DD, huh? Printer will have played DD. And all your counsels, whoever it is, who are for the petitioners, give me the details as regards your case number. Then before the tribunal, what is the impugn order by which section 5 was exercised? And whether DAR and R has been submitted or not. Just give a slip, all the cases. By tomorrow, you also, where it has been dismissed, in which case, and particular tribunal, because then I have to pass appropriate directions to them.
Respondent should not be answered.
No, respondents will only give your names in which matter you are appearing. And we appreciate Mr. R. Borbujari and Mr. D. Nath. He has done a lot.
In respect of all the cases, because capacity of whether R and R was. As given that judgment, that in my case, R was submitted or not.
You let me know by tomorrow. Can you get it? Just make a mention and let me know. Just find out and let me know. You make a mention tomorrow and let me know in which cases, or put a note out there where DAR has been submitted or not. And give it.
There is very bias. So there is wide option still awaited, but I think that this treatment of the order bypass notification as well as verification given by the finance department. First, we make specific standard only -10 and +10%. What is only? Here the finance given a clarification, there is no cap. The notification clearly says that if it goes beyond 15%, below 15%, the threshold amount will be given amount. So may I please mention, there's a separate authority your lordship, the tender notice that page 19 your lordship. Sorry, 18 your lordship. Wrong, 7 your lordship. Here this appeal against decision, action or omission regarding this particular procurement. May do so as per section 30 of the Assam Public Procurement Act 2017, good variations in the Assam Public Procurement Code 2020. The first and second authority as mentioned below. First authority is the secretary to the governor of Defense Forest, second secretary to the governor of finance. So since the decision was taken to cancel the tender process and go for re-tender, actually for agreed by tender. The petition agreed by that order cancelling the tender. Approach these authorities with all this finance notifications or clarification given by the finance authority.
We are concerned with cancellation corrigendum dated 19/5/2025. Annexure 8. And which work we are in concern?
Original minus there simple say that as for the data extract of eight by the PCF of the external results. After cancel the tender has been canceled. Later in his affidavit manner, it has been disclosed that the entire tender has been booked. The tender has been as per the Japan notification. In fact, my lord, as per the clause 2 of the tender, the tender placed 18 my lord. 2 mile. Cost 2 mile. That is that bidding will be conducted through the open competitive bidding method and procedures as specified in the Assam Public Procurement Act 2017 and Assam Public Procurement Rules 2021. This act and rules may be viewed and downloaded from the website provided to however, the question is there in the affidavit is air affidavit manner categorically stated that in paragraph 6. And the tender has been conducted as per the provisions of the Rules and Act of the Assam Procurement. 17 Act and 20 rules. And in this regard, my finance department has that is a hard tax matter.
Now, whether this annexure A to your affidavit was a part of your notice inviting bid?
No.
No, we are not going to send it after finding out all these things. We set aside this decision of the corrigendum. They will file appeal and what will happen? It is not going to help your purpose also. You want the work to be done. You will give additional security. Whatever may be, you give it or not give it, that is your lookout. But when a matter comes before this court, I think it is a high time we need to deal with it. Heard Mr. D. Bolwar, the learned counsel, appearing on behalf of the petitioner. Mr. R.R. Gogoi appears on behalf of all the respondents. This court also heard Mr. B. Gogoi, the learned Additional Advocate General, Assam, who is also the Standing Counsel of the Finance Department of the Government of Assam. The petitioner hearing has approached this court, being aggrieved by the cancellation corrigendum dated 19/5/2025 issued by the respondent number 4, and further seeking appropriate directions upon the respondents to issue the work order in favor of the petitioner in respect to the work of inverted comma construction of range office cum range office quarter comma Goramur. Facts of the case. The Divisional Forest Officer, Majuli T Division, issued a notice inviting tender dated 18/1/2025, inviting bids from eligible bidders for construction of range office cum range quarter Gormur, as well as for RCC building bracket forest guard oblique game watcher oblique grade 4 quarter and anti-poaching camp. The present petition relates to construction of range office cum range quarter Goromur, isn't it?
Yes.
Wherein the estimated cost was mentioned in the notice inviting tender at rupees 46,98,000. It is specifically mentioned in the said notice inviting tender, and more particularly at clause 2, that the bidding would be conducted through open competitive bidding method and the procedure as specified in inverted comma the Assam Public Procurement Act 2017 and the Assam Public Procurement Rules 2021 would be followed. First, the petitioner, along with various other bidders, participated in the said tender process for the construction of range office cum range office quarter under Gormur range. All the 6 bidders, including the petitioner, were found to be technically competent. The petitioner's bid was the lowest. Having quoted an amount of rupees 38,51,999. This was duly intimated to all concerned in the e-portal of Assam tenders dated 29/3/2025. The petitioner thereupon awaited that the work order would be issued to the petitioner. However, to the surprise of the petitioner, on 19/5/2025, the tender process in respect to the construction of range office range office quarter Gormur, as well as the tender for construction of ground floor with provision of 3-storied RCC building, forest guard, game watcher, grade 4 quarter and other quarter were cancelled.
That is the another bill. Second part is the another bill. I'm not concerned about that.
I know that. Have I not mentioned in the first half? I hope you don't teach me how to draft my judgment. There was no reasons provided for issuance of the cancellation corrigendum dated 19/5/2025. And the petitioner, therefore being aggrieved, had approached this court challenging the cancellation corrigendum dated 19/5/2025 by filing the present petition, seeking the reliefs as already aforestated. It is seen that this court, by an order dated 23/6/2025, passed an interim order that the respondents, thereby restraining the respondents from issuing a fresh tender in respect to the tender in question. The records reveal that this court issued notice on 22/7/2025. On that same date, when the matter was taken up, the counsel appearing on behalf of the respondent, on the same date when the matter was taken up, the counsel appearing on behalf of the petitioner brought to the notice of this court a notification dated 30/7/2024, issued by the Finance Establishment Department in exercise of powers under Rule 30(5) of the Assam Public Procurement Rules 2020, whereby stipulations have been, whereby it is stipulated as to what steps are required to be taken if the bid value is below 10% to the estimated cost of the project. The record further reveals that an affidavit in opposition has been filed by the respondent number 4, wherein it is the stand taken from by the respondent number 4. From a perusal of the said affidavit in opposition, it is revealed that on the basis of the communication issued dated 10/5/2023 by the additional principal chief conservator of forest and chief executive officer, state CAMPA, CAMPA, whereby it is mentioned that the limit for financial bid shall be between -10% to +10% of the internal estimate, and any bid value beyond the said limit shall be outrightly rejected at the time of opening of the financial bid. It is therefore the case of the respondents in the instant writ petition that as the bid value of the petitioner was rupees 38.51 lakh, amount to 38.519 38,51,999.99 against the estimated work value of rupees 46.98 lakhs. The entire tender process was cancelled, taking into account that the petitioner was the lowest bidder. It is specifically mentioned that the petitioner's bid was 18.01% less than the estimated amount as per the funding agency Camper guidelines. The petitioner thereupon submitted a reply wherein the notification dated 30/7/2024 was wherein the petitioner reiterated and reaffirmed the statements made in the writ petition and additionally inserted pleadings in respect to in connection with the notification dated 30/7/2024 issued by the Finance Establishment B Department of the Government of Assam, issued in exercise of the powers under Rule 30(5) of the Assam Public Procurement Rules 2020. Taking into account the said aspect, this court, by an order dated 10/11/2025, requested the Standing Council of the Finance Department to apprise as to whether the notification dated 30/7/2024 issued by the Finance Department shall override the communication dated 10/5/2023 issued by the Additional Principal Chief Conservator of Forest. Pursuant to the said order passed, Mr. B. Gogoi, the learned Additional Advocate General, have placed before this court an instruction issued by the Joint Secretary to the Government of Assam Finance Establishment B Department, dated 21/11/2025. The contents of the said communication dated 21/11/2025 is relevant, and as such, the same is reproduced hereunder. Y contents from Joint Secretary by Government of Assam is signed Kurisi. A to copy to Nalagi, memo number to deliver. Taking into account the above notification, this court gave an opportunity to the respondent departments to seek an instruction as to what steps they are going to take in view of the stand taken by the Finance Department, more particularly when the notice inviting tender categorically mandated that the procurement would be made in terms with the Assam Procurement Act, so and so, as well as the Assam Procurement Rules, so and so, and the notification dated 30/7/2024 was issued by the Finance Department in exercise of powers under Section Rule 30(5) of the Rules of 2020. The present writ petition was accordingly fixed today for final disposal. to back facts with submissions. Submissions made by the learned counsels appearing on behalf of the parties. Mr. D. Burwa, the learned counsel appearing on behalf of the petitioner, submitted that taking into account the notification dated 30/7/2024 and also the stand which is taken by the finance department, the respondent authorities would not have bypassed the notification dated 30/7/2024 in order to cancel that said tender process and issue a cancellation corrigendum, impugn cancellation corrigendum dated so and so. The learned counsel further submitted that the petitioner was ready to deposit the additional security, performance security, which was never asked by the respondent authorities. Mr. D. Burwa further submitted that in spite of submitted that the tender the notice inviting tender categorically mandated that the procurement would be made in terms with the Assam Procurement Act so and so, the Act of so and so, as well as the rules of 2020. And under such circumstances, except for reasons other than bona fide, the actions, the respondent authorities ought not to have cancelled the said tender process. Mr. B. Gogoi, the learned additional advocate general, Assam, who is also the standing counsel of the finance department, submitted that taking into account the notification dated 30/7/2024, taking into account that the notice inviting tender categorically mandated that the procurement would be made in terms with the Act of 2017 and read with the rules framed therein under, the respondent authorities were bound in terms with the notification dated 30/7/2024 inasmuch as the said notification has been issued in pursuance to Rule 30(5) of the Rules of 2020. He further submitted that this very aspect of the matter have been duly mentioned in the communication dated 21/11/2025 issued by the Finance Department of the Government of Assam. Mr. R. Gogoi, the learned counsel appearing on behalf of the respondent, however, submitted that the communication issued by the respondent by the additional Principal Chief Conservator of Forest and the Chief Executive Officer of State Kampa, dated 10/5/2023, was holding the field, and as such, the said notice on the basis thereof, the impugned cancellation corrigendum was issued. He therefore submitted that as the bid so submitted by the petitioner was 18.01% below the estimated cost mentioned in the tender document, the respondent authorities have acted fairly in complying with the communication dated 10/5/2023, and as such submitted that this court may not interfere with the impugned cancellation corrigendum dated so and so. Isn't it, Mr. Aragu?
And what is the main thing, page 51, there for page 51, thereafter the division courts officer, the affidavit. That's each one. But that's available.
What is that?
It says that the undersigned that from the other superintendent of furnished by you. Because of the regulation criteria of accepting the class minus percentage are not mentioned in the standard bid of 198. The evaluation criteria section 4. The SPT company deviate from the standard criteria with the SPT. I see your request to revise the SPT as the existing guidelines. Proceed. We tender the above mentioned for termination.
What do you want to say about this?
So, since the reason is first class minus, they said only class step minus and etc. Thereafter, this termination says that the criteria section for the bid document, the criteria is not given at all for evaluation. After scrutiny, therefore, retender was called for. Retender was called for since this criteria, evaluation, the qualification criteria section 4 is completely deviates from the standard criteria in SP.
Which criteria?
Section 4, the evaluation is qualification criteria.
Of the tender document.
Yes, and here the issue is that it's not a complete tender document.
Section 4,
Section 4 is not here.
where is that? Clause?
But if evaluation qualification section 4. The impression this is not for your honor, right?
I'm aligning with the, and even also now that, I have.
Where is section 4?
Not an accident.
But that is for retender.
Yes.
This is in furtherance to retender. No?
There was, that class set minus percent was there, this one the top.
The learned counsel further submitted that prior to issuance of the impugned cancellation corrigendum, who is the DCF means?
Okay.
What is the full name of DCF?
The
The Deputy Conservator of Forest have issued a communication to the Divisional Forest Officer to revise the standard bid document as per the existing guidelines and proceed to retender the work without delay. And it is under such circumstances the impugned cancellation corrigendum was issued. With analysis and determination. This court have duly taken note of the notice inviting tender and close to the writ petition. At section 1, clause 2, it is categorically mentioned that the bidding would be conducted through open competitive bidding method by following the procedure as laid down in the Act of 2017 and the rules of 2021. This court inquired during the course of the hearing as regards the reason why at clause number 2, there is a reference to the Assam Public Procurement Rules 2021. upon Mr. D. Gogoi, R.R. Gogoi appearing on behalf of the Forest Department, the Learned Counsel submitted that the reference made therein is actually to the Assam Public Procurement Rules 2020, which have been amended as on 2021, isn't it? That must be the reason, otherwise, because down below you are saying. Taking into account the above, it is therefore the opinion of this court that the Assam public that the manner in which the procurement is required to be carried out has to be in terms with the Act of 2017, read with the rules framed therein under. First, the materials on record categorically show. Now, first of all, this court have further perused the notice inviting tender, and there is no reference in the said notice inviting tender in respect to a viable rate that is plus minus 10%, and the bids are to be quoted within the said rate, said range, failing which the bids would be rejected. This court have also duly taken note of the communication issued by the Additional Principal Chief Conservator of Forest and Chief Executive Officer, State Camper, dated 10/5/2023, the basis on which the respondents have taken action. The said stipulations, full stop. A perusal of the said communication reveals that the limit for financial value has to be between minus 10% to plus 10% of the internal estimate. It is further mandated that if any bid beyond the above limit, the same shall be outrightly rejected at the time of opening of the financial bid. This court inquired with Mr. R.R. Gogoi appearing on behalf of the Forest Department as to whether there is any internal estimate provided in the bid document. The Learned Counsel submitted, with fairness, that there is no internal estimate. What is mentioned therein is the estimated value of the bid in the tender document. Taking into account that there is no mention in the bid document about rejection of the bid if a bidder quotes beyond the range of minus 10% and plus 10%. The rejection of the bid, the decision to cancel the tender process on the basis of the petitioner having quoted less than 10%. Appears to have been done by taking into consideration a hidden criteria, which was not open and transparent, a facet required for the state authorities to undergo wherein when the state authority, a state enters within the contractual domain Let's go further. Finds it also relevant, besides the aforesaid, to take note of the notification dated 30/7/2024 issued by the Finance Department of the Government of Assam in exercise of the powers under Section Rule 35(5) of the Rules of 2020. A perusal of the said notification there dated 30/7/2024 mandate that the tender inviting authority will indicate in the bidding document that quality is dependent on the cost and that has to be supported by clear certification from the head of the department of the tender accepting authority or the officer having relevant technical sanction power. Now, a perusal of the said document, notification dated 30/7/2024, reveals that if the bid of a successful bidder is at a discount of more than the threshold value of 10% below the estimated value put to the tender, then the tender inviting authority shall seek written clarifications of the justifications from the bidder for quoting such price, including detailed price analysis of its price bid in relation to the scope, schedule, allocation of risk and responsibilities and any other requirement of the bid document. This court have duly taken note of the notification dated 30/7/2024. Clauses 1.1, 1.2, 1.3, 1.4, and 1.5 being relevant is reproduced hereunder. From the above quoted clauses of the notification dated 30/7/2024, it is seen that the tender inviting authority, who are the respondents in the present case, are required to carry out an exercise if the bid value is below 10% of the estimated value. However, admittedly, nothing was done in that regard. The respondent authorities merely on the basis of the communication dated 10/5/2023 issued by the additional chief engineer so and so have cancelled the entire tender process. It is also seen from the document kept on record and marked with the letter Y, the contents of which have already been quoted herein above, that the said notification dated 30/7/2024 was binding upon the respondent authorities. Therefore, it appears that the cancellation of the impugned cancellation corrigendum dated 19/5/2025 appears to be an arbitrary and an unreasonable exercise of power In this regard, this court finds it relevant to take note of a recent judgment of the Supreme Court in the case of the state of Himachal Pradesh and another versus Oasis Cybernetics Private Limited, OASYS, reported in 2025 SCC Online SC 2536, wherein the Supreme Court, dealing with the question as regards the cancellation of tender, observe that when an exercise of power is found to be prima facie unreasonable, now observe that when contractual rights are absent, the state's administrative discretion in rescinding or cancelling is not unfettered. It remains subject to constitutional discipline, particularly the requirement that the state action must not be arbitrary, unreasonable, or actuated by malafide. The Supreme Court further observed taking into account that in the instant case, that the reasons for which the impugned corrigendum was issued, cancellation corrigendum is issued, is contrary to the bid document, in as much as the bid document does not contain any such terms and conditions and is based upon a hidden criteria. And secondly, the said exercise was carried out without following the mandate of the notification dated 30/7/2024, issued by the Finance Department. It is therefore the opinion of this court that this is a fit case for interference with the impugned cancellation corrigendum dated so and so. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The impugned cancellation corrigendum dated so and so is set aside and quashed. Number two, the respondent authorities, and more particularly the respondent number 4, is directed to carry out the evaluation of the bidders, including the petitioners, in terms with clauses 1.1 to 1.5 of the notification dated 30/7/2024 issued by the Finance Department. Number 3, on the basis of such verification being carried out, the respondent authorities shall take due steps in accordance with law. You ask for all these things. I'm not asking you to give it. Because sending him to the appellate authority makes no sense.
The main issue with we were just titled because the tender document clearly says that it will follow this rules and act. The main reason was something that you're not.
No, on one hand, you are categorically saying that you are going to follow the Procurement Act and the rules. Then how can you be? But I think you have got 1.1 is the very important thing. And you also need to have a certificate which is as per 1.
Oh.
Well, look,
21, 2 PM.
Take some more time, Lordship, the report has not received, Lordship. Not received, Lordship. Take more time.
So without records, we have to presume that there is no records.
Not produced with the Lordship.
No, we have to presume that there is no records, man.
Last order, Lordship is correct.
I've given you the opportunity for more than 1 month.
Lordship, some of the meetings were after GLC meetings were held in BCO. That's why you are correct, that records were not yet with the municipal. They are collecting. But if some immediately reopening.
We impose a cost.
This last.
Otherwise, it becomes difficult on the part of this court in view of that order passed. Cost of 10,000. Give you an opportunity, but 10,000 cost. On 3/11/2025, when the instant writ petition was taken up for final disposal, this court directed the Tinsukia Municipal Board to submit instructions as well as the contemporaneous records, thereby fixing 13/11/2025 at 2 PM for final disposal. On 13/11/2025, the Tinsukia Municipal Board, the council appearing on behalf of the Tinsukia Municipal Board submitted that the chairman of the Tinsukia Municipal Board had instructed the learned counsel to inform this court that without that executive officer, none of the records could be produced. This court, taking into account the same submission, fixed the matter today at 2 PM for production of the records as well as further observing that if on the next date no records are produced, presumption would be drawn that such records do not exist. Today also, when the matter is being taken up, Mr. S.S. Roy, appearing on behalf of the Tinsukia Municipal Board, submitted that the records are all the records are not available to be produced and have therefore sought for a further date on the reopening. It is the opinion of this court that the stance so taken by the Tinsukia Municipal Board to delay the disposal of the present writ petition it is the opinion of this court that the non-production of the records have led to the delay in the disposal of the writ petition. Thereby resulting in valuable time of this court being lost. Taking into account that a final opportunity is being sought for production of the records, this court fixes the matter on 21/2026 as the last and final opportunity for filing for production of the records. This court also taking into account the delay caused in the disposal of the writ petition by the Tinsukia Municipal Board imposes a cost of rupees 10,000 upon the Tinsukia Municipal Board. The Tinsukia Municipal Board shall deposit the said cost of rupees 10,000 before the registry of this court on or before 19th of January 2026. Failing which, the same shall be recovered as areas of land revenue from the Tinsukia Municipal. The appropriate directions would be passed for recovery.
Date on 20. 21 or 20?
20. Yes. 21 is Wednesday, 20 at 2 p.m.
In the mapping part, I think it would be better.
See,
The substantial part.
Item 23, except to be.
Clearly. The tender action. It actually is exceeded by the rejection of the technical bid of the bid. The tender is at page 25. The rejection of the petitioner is at page 56. Page 56. Comments or that's what it.
yes,
Page 56. Altered format of annexure 5, para A, submitted by the bidder. But here what happened is, before 14/5/2024, annexure 4 at page 53, this is a railway circular. So, before this, the bidders were to submit the hard copy and to upload the hard copy of the annexure 5 of the tender document.
now, Mr. Saiwala, you duly admit that your online submission is different from the offline.
Lordship, offline, there is no system. In Lordship, may see the circular one. In this regard, Lordship, may see the circular at page 52. Offline submission was made not for second para on IR
Page,
53.
yes,
Second para, third para, on IRPPS model, a facility has been created
for online submission of annexure file. Therefore, the provision of downloading of annexure file of BCC and uploading of physically signed copy of annexure file by the tenderer has been discontinued. IREPS is what is Indian Railways Electronic Procurement System. So, thereafter the rejection was based on the annexure 5 para A. Now, Lordship may come to my petition at page 9. I have made a tabular form, tabular chart of the format, the physical copy submitted, and the online. The left hand side, Lordship got it. But the only difference is in the middle one, the physical copy, which are not to have been submitted by the petitioner, but due to inadvertent error, the petitioner, along with the online submission, has also uploaded the offline copy. Here, one of the in bold or incorrect in the middle column logic, or incorrect was extra in the physical copy submitted by the petitioner, and the second bold part logic, and may also lead to any other action provided in the contract. This was not there in the physical copy. Now, let me come to my affidavit in reply. I have annexed annexure 5 from a different contract.
Annexure?
In my affidavit in reply, page 95. This is the format from a different contract. These are the, this is the annexure 5. We need to click it on the right side box. Thereafter,
Page?
page 95. Affidavit in reply. This is the annexure 5. On all the right hand side boxes, we need to click it. And thereafter, we need to upload a annexure 5A, which is at page 97. That is a declaration regarding if the petitioner is a partnership firm, if it is a joint venture, or a HUF, or a LLC. So this we have to upload at page 96. After the clicking of the right side box. Down, select file to upload. This is the only upload the petitioner has to do. Here now the rejection order is only based on altered format of annexure 5 para A. Here. Now we come to their affidavit in opposition. But the affidavit in opposition at page 60. Para 5. So second para of para 5. At page 65. Their objection.
Yes, what is that?
On page 65, their affidavit in opposition. Para 5, second part.
Yes.
Mary, the online certificate as mentioned by the petitioner is not a certificate but a format provided in the tender documents for the guidance of the bidder. Whereas Lordship, the online provision was created by the Railway Circular dated 14/5.
But you have not challenged the provision, na?
Lordship not.
Clause 3 of the tender condition have you challenged? My question is this, you see, kindly come to clause 3, clause 2. Clause 2 of the tender condition. Kindly come to this. Where is the document? Where is the tender?
Eligibility criteria, page 31.
Now kindly come to page 86. Tenderers are compulsorily required to submit a certificate as per Annexure 5 of the Schedule A. Without that, offer would be considered incomplete and will be summarily rejected.
Yes, Your Lordship, we have given the online provision.
No. Where is the online? It has to be given the offline, whatever may be. It is categorically given there.
But the offline is only the annexure 5A.
No. This is online. As per Annexure 5, it is categorically given. Kindly see. Roman 2,
Page number.
page 86.
Affidavit in reply.
Or whatever may be. Your reply or whatever may be. No. It is a part of the affidavit. Page 77 otherwise. Actually, it is 86, whatever may be. You have not challenged this condition.
Madam, that is submitted certificate is, the Lordship may see the railway circular once.
Forget about circular. You have to challenge that. This is the circular. Why on earth did you change it? Not once, twice. You have given the certificates of both of your joint ventures, wherein you categorically mentions the same paragraph 8 you did. This is manipulated. Or any other. What is the words?
Page 9.
What is required is this.
Lordship, what is required is in the left hand column.
No, what is required is this.
Yes, 7.
You have to survey and may also lead to any other actions provided in the contract, including banning of business of beer. That is not there. Rightly rejected. I only gave them the chance on that last occasion to file an affidavit. Otherwise, I would have dismissed the petition on that day at the hands of Mr. G. N. Sahibada. But good. Now I will get the dismissal at your hands.
Lordship, the only rejection was that altered para.
Absolutely, para is, it is the mandate of that.
Lordship, but in the online.
What about the online? We are not on the online. Online, they only tick the box.
Lordship, that is the only provision. The physical copy has not ever been considered.
Then why on earth did you submit the physical copy?
That was an error.
No, why have you submitted the physical copy? Isn't it, madam? Everybody has submitted the physical copy. Now, others also have submitted the physical copies. What?
Hello?
Are you understanding what am I saying? Have all other bidders submitted the physical copy of Annexure 5 or not?
Actually, for affidavit, whether another leader has submitted or not. But here, case pilot, and it is that they have modified their affidavit manual. That is the true pilot, and in this regard, our pilot already.
Lordship, we see the online one from there.
And that is for a kindly come to case number 81, pilot. When we acted in case number 87, when the time we come to it, the meeting is inside of the case number 87, there are 7.
Yes.
Case number 87, there are
I mean that there has been no admission of any tampering or modification, while the answering deponent states in the requisition was that the petitioner on a bona fide belief furnished the online certificate under so and so in the correct format, but unfortunately the petitioner along with the same also uploaded the IMAN in the earlier format of Annexure 5. The petitioner has duly furnished the certificate of IMAN in the correct and prescribed online format as required by the Railway Board Circular dated so and so. The additional uploading of the physical was only inadvertent and made in the old format of Annexure 5 due to lack of knowledge of the state circular issued by the IMAN without any intention to temper or modify. Are you banning them? Where is your rejection?
Page 56, Lordship.
Page
56. From altered format of Annexure 5 to Para 8 submitted by the Customer wants to see the online submitted by the.
How do I see it online?
Lordship, from their affidavit itself.
Where is it?
Lordship, at page 81. After the first August.
Yes, what is it?
I, Babul Nath, appointed as the attorney authorized signatory of the tenderer and its PN infra project. Herein matters the serial number A. This is in the format which I put to your lordship in the now affidavit in reply. This is the actual format as per the railway circular. Para 8 has all the same document, same wordings as the format. Thereafter, at page 83, your lordship, the digital signature used has also been at page 83.
Now kindly come down. Page 90, page 81, down. Submission of document verification partnership so and so. Please submit a certificate in the prescribed format.
Lordship, that is Annexure 5.
Non-submission of the certificate submission of the certificate either not properly filled in or in the format other than the prescribed format shall lead to summary rejection of your offer.
This is Annexure 5A. The above is the Annexure 5.
How do you say?
Lordship, in my affidavit in reply,
No.
at page 95, I finished the format from a different contract, format of Annexure 5, but the wordings are same. The online signature used has also been noted down at page 83.
What is this Annexure 4? This is by submission by whom?
Annexure 4 is the bid of the petitioner. The bid
The
of the-
Annexure 4 is DW 81 is the certificate. He's got both his signature, not signature, his name in the content above the certificate.
The signature is down below.
There is no signature also.
Online signature is down below at page 83.
It is a
60 dollars. Next. That's all.
Why did you give these two certificates of Babulnath and Mr. Dev?
Lordship, these are the signature of the LLP partnership firm.
No, why did you give the two certificates of Annexure 5?
5A, that is 5A.
No,
The hard copy, the physical copy was submitted with the important.
no, for both parties, why did you say?
When both parties, there's only single one. In the online, I have.
No. Only see, Annexure page 71 or what is it? 71 or 80? 71. This is by Babulnath and the next one is by Mr. Dev. Now,
This is the hard copy.
why did you submit two?
This was the.
No, why did you submit two
But
and
partner-
put the signature of only one? I only asked you that.
Signature, both the parties have been put, my lord, at page. Only online, my lord, at page.
Online only one has given.
No, my lord, at page 82. You lordship may see the above table. Partner firm, Sarvika Nag and Babu.
No, if that be so,
Lordship.
submission of the document verification certificate. If this be so, this is the document attached.
Lordship,
Kindly see this. Why I am saying it.
Lordship.
This document which is being attached is the Annexure 5.
No, Lordship, that is Annexure 5A, Lordship.
No, then where is Annexure 5 attached? Where are we attaching Annexure 5?
Annexure 5A,
And if it is Annexure 5 only,
Lordship,
if it is, this is 5A,
5A.
then this is a certificate where it is being signed by two partners.
Whether it is a LLP.
Whatever may be. But what about 5? Then in respect to this, why only Babulnath has signed?
Online signature, my lord, only.
Then why it is in the next one there are two signatures?
Lordship, that is 5A, that is.
So
document is
therefore,
uploaded.
in Annexure 5, there's only one signature.
One signature.
So, but why it is,
In the online submission, my lord, at page 83, Lordship may see one.
now, so where is your scope of, where is your scope for putting the Annexure 5 in this document?
Lordship,
Because here you see, kindly see this, page 80.
Lordship,
Standard technical criteria as follows, doc so and so 1, 2 and 4.
Lordship.
Is it in page 80?
Doc 1, doc 2 and doc 4.
Lordship.
So which is the document which you have enclosed as Annexure 5? You have not given by hand. What is required is
That I have to take instructions on that.
not necessary. Today we are finishing it off now, right now. Instruction for appeal, nothing else. Dismissing right now. But only I am asking you, giving you an additional. If Mr. Sahewala was there, senior one, I would not ask him. But you are a junior counsel, so I am giving you an additional opportunity. Yes.
Lordship,
What is this doc 1, doc 2 and doc 4?
these are the documents to be uploaded.
So therefore you have uploaded Annexure 5
Lordship.
somewhere where the document is faulty.
That document that has been annexed by them at page.
I understand, Mr. Mayank Sahewala, you kindly appreciate your submission, I get it. You say that look here, I have tick marked all these things at page 81 and given this certificate, which is a part of that certificate which I have uploaded. So that I have already done. When I have done that, where is the question of that document of Annexure 5? Meaning thereby, you have not given Annexure 5 either, which you have given. There's no quarrel with that proposition. And that Annexure 5 is a faulty document. Where in this column, in this application, you have uploaded Annexure 5. My question is that. Because you see, the next document, which you are saying as 5A, here you have this I partnership firm, joint venture and so. You see, the first one is C. You have a certificate, I, Babulnath, appointed as attorney authorized signatory of the tenderer so of the Iman of so do hereby solemnly affirm and state on behalf of the tenderer, including the constituents as under. So you are saying all these things.
This is annexure 5.
Then kindly see the next. I partnership firm, joint venture, Hindu undivided family, limited liability firm. Please submit a certificate in the prescribed format. Downloaded the format from the link given below. Non-submission of the certificate or submission of a certificate either not properly filed in or in the format other than the present format shall lead to summary rejection. Now, this is the document you have enclosed. Why are you saying this to be Annexure 5A? Here you have the signature of both.
Lordship, I can show that.
If it is an individual tenderer, you don't require this certificate.
Lordship, I can show that from the format I have annexed with my affidavit in reply. Lordship, may kindly see once at page 97.
Yes.
This is annexure 5A. Lordship. This is regarding the partnership from joint venture, which your Lordship said. Second part. I so and so authorized signatory of member partner of the tendering authority. I hereby constitute is here not blacklisted or debarred by residence or any other means. This is in respect of the LLP.
But show me where is the certificate under 5A required to be submitted in this particular tender document?
But this is with the annexure 5B.
In this tender document, there is no Annexure 5A.
The second part is
Where is Annexure 5A?
Lordship, it
Because
is
you
not,
see-
not written, but it is written.
No,
Mr.
Mr. Sahavadar, enough, too much.
Last para. it says-
No, Mr. Counsel, you kindly see this particular tender document. Where is it again, the tender document gone? Where is the tender document? 70? Your page and my page is different. Why don't you look into this properly? 77. Now, kindly show me in the tender document
Lordship,
that there is a requirement of submission of an Annexure 5A.
Lordship, the note number 3.
Where?
Note number 3 at the first page, Lordship, 77.
In case of other than the company proprietor firm, Annexure 5A should be submitted,
By each member of partnership firm. So this is the 5.
signed by themselves or through the attorney authorized of the individual here. So therefore, Annexure 5A is required to be submitted. So that is the document which you have submitted as Annexure 5A.
Lordship, both the partners were.
But where have you included Annexure 5?
Lordship, not to be enclosed as the format I have shown at page 95, your Lordship may see one, my affidavit in reply. Because annexure 5, we need not upload as per the railway circular, Lordship. This is the format from a different contract. Here on the right hand side, we have to click the boxes, and thereafter down below at page 96, we have to upload the annexure 5A.
Then, what do you say about this page 77?
That Lordship, that should not have been there, note number 2, because that was discontinued by the railway circular dated 14/5/2024.
But then also this is there. Have you challenged this?
Not challenging this.
Then, if this requires this, Annexure 5 has to be there. But you have duly submitted Annexure 5.
That was in the earlier format.
Whatever may be, but you have submitted the Annexure 5. Otherwise, they would not have got these two documents, which is
We have
there
submitted.
at page 71 to 73.
Lordship, we have done it. That
So
is
you
not
have
it.
submitted. Where you must have submitted in that e-portal itself.
Lordship,
So
That
there,
one
this
is-
certificate in number 8 is wrong.
Lordship.
Then how can you raise unless you challenge this clause too?
Lordship may allow me to amend it.
How can you amend it?
or
After this,
leave it.
after submission of the bid, you want to do it. But tell me. Yes, tell me. It's. So you want the dismissal in your hands or in Mr. Zien's?
Well, only thing, but as per this, page 53, only that one certificate is considered.
Huh?
As per railway circular.
No, understood, but that is, therefore you have to challenge that clause. You have acted on that clause. Rather than challenging, you have acted on clause 2 and submitted Annexure 5. Now, what is your submission? Then look here, Annexure 5 was not necessary in view of the railway circular.
That is only where that is why they should consider only one certificate.
So therefore, you see, they say that Annexure 5 is required. You say that as per this particular railway circular, Annexure 5 is not required. A certificate where the tick mark is being given is enough, due compliance. So kindly disregard what I have given as Annexure 5. That is your submission. But the fact remains the tender condition categorically mentions there is an Annexure 5 required. And you have acted on that and have submitted an Annexure 5. Problem arises there.
That condition is modified by the Annexure 5 the circular. Actually modified.
I would have understood this modification happened subsequently. In spite of that, which is of 2024, they have issued a tender condition of the year 2000, tender in the year 2025. So they have not adhered to the railway circular on that. But for that, I have to set aside that annexure note 2, which I can't. That case, okay, at your heads. Heard Mr. G.N. Sahewala, the learned senior counsel, assisted by Mr. M. Sahewala, appearing on behalf of the petitioner. Ms. A. Gayan appears on behalf of the respondent authorities. The petitioner herein is agreed by the action on the part of the respondent authorities in rejecting the bid of the petitioner, technical bid of the petitioner. By the intimation given on 22/9/2025. Brief facts of the case. Who has issued this document? The Office of the General Manager, bracket CON, bracket close, NF Railway, had issued a notice inviting tender bearing notice number CON/2025/JUNE/02 dated 12/6/2025. Then I put his name only. He has done everything and now you don't want the real name. Okay, no problem. So and so. For construction of cut and cover tunnel on pile foundation with touch piles on both sides between CH 39457-39492 and cut and cover tunnel bracket open foundation between CH 39492-39620 as slope protection measure in connection with Dimapur bracket Dhansiri Kohima bracket Jubja bracket close new BG railway line project. The petitioner participated in the said tender by submitting the bid full stop. However, on 9/7/2025, the petitioner's techno-commercial bid was found technically unsuitable. And the said aspect was informed to the petitioner on 22/9/2025 by an email assigning the reason about altered format of Annexure Roman 5, para 8 submitted by the bidder, assigning the following reason, inverted comma, altered format of Annexure Roman 5, para -8 submitted by the bidder, inverted comma, close. The petitioner, upon receiving the said communication, submitted a representation on 23/9/2025 for reconsideration. On the basis that there was no necessity for submission of the Annexure Roman 5 in view of the Railway Board Circular number 2022/CE-Roman 1/CT/GCC correspondence dated 14/5/2024. And further stating that the petitioner's bid being lower than the declared L1 bidder, the respondent authorities should reconsider their stand. Having not received any favorable response, the present petition was filed. This court, by an order dated 26/9/2025, issued notice. However, taking into account the instructions so placed by the learned Central Government Standing Council, dated 25/9/2025, which is kept on record and marked with the letter X, this court was not inclined to pass any interim directions. The record reveals that the petitioner and the respondents have filed their affidavit in opposition in the meantime, wherein the specific stand so taken is that the uploaded compulsory certificate in Annexure 5 was tempered or modified as compared to the standard format of Annexure 5 of the tender document in para 8. It was further mentioned that in note Roman 2 of the tender notice dated 12/6/2025, tenderers were compulsorily required to submit a certificate as per Annexure 5 of the tender documents, and without that offer will be summarily rejected. It was further mentioned that the online certificate as mentioned by the petitioner is not a certificate, but a format provided in the tender document for the guidance of the petitioner bidder. The bidders are required to submit all certificates at designated places. That is point number 1 under technical compliance of the tender document. It was further mentioned that a copy of the declaration by the petitioner said online certificate does not have signature bracket physical or digital of the petitioner. Hence, the said document cannot be treated as a valid document. It was further mentioned that there was no valid online certificates uploaded by the petitioner. And as per Annexure 1 submitted by the petitioner, if the bidder tampers or modifies the tender form, which are downloaded from the internet site www.ireps.gov.in, the tender would be summarily rejected. It was therefore mentioned that under such circumstances, the petitioner's bid was summarily rejected, technical bid was rejected. The petition to the said affidavit in opposition, the respondents have enclosed the certificates in Annexure 5 uploaded by the petitioner, by the designated partners of the petitioner. In addition to that, the format for the certificate to be submitted or uploaded by the tenderer along with the tender document in Annexure 5 was also enclosed as Annexure Room 2. The technical bid submitted by the petitioner was enclosed as Annexure 4 to the affidavit in opposition. The record further reveals that the petitioner thereupon filed an affidavit in reply reiterating its stand taken in the writ petition. To the effect that in view of the Railway Board circular dated 14/5/2024, the question of uploading the Annexure 5 did not arise. To the said affidavit in reply, the petitioner enclosed the tender documents in respect to another tender wherein the petitioner participated, which is as per the GEM/IREPS portal, wherein, as per the petitioner, the certificate in terms with Annexure Roman 5 is not required. And what is required from the bidder is only to fill up the boxes and submit it and upload the respective forms. In the backdrop of the above, submissions made on behalf of the learned counsels appearing on behalf of the parties. The learned counsel, senior counsel appearing on behalf of the petitioner submitted that the rejection of the petitioner's bid on the ground that the document enclosed on the ground that Annexure Roman 5 so uploaded was unfair and arbitrary, taking into account that the state Annexure 5 was not at all required to be submitted in view of the circular of the Railway Board dated 14/5/2024. The Lalit Senior Counsel submitted that pursuant to the circular issued by the Railway Board dated 14/5/2024, when a bid is called in the IREPS module, as the facility has already been created for an online submission of the Annexure 5. Therefore, the provision of downloading of Annexure 5 of the GCC and uploading of the physical signed copy by the tenderer has been discontinued. The learned counsels, therefore, senior counsel, therefore submitted that taking the circular dated, taking into account the circular of the Railway Board dated 14/5/2024, it is the respondent authorities are bound to adhere to the same. In spite, the learned senior counsel also submitted that this aspect was brought to the notice of the respondent authorities by the representation dated 23/9/2025. However, the same have not been taken into account. Under such it is under such circumstances, the learned senior counsel also submitted that non-consideration of the petitioner's representation and insisting to continue to disqualify on the basis of the physically downloaded, physically signed Annexure 5 is contrary to law and renders the action on the part of the authorities unfair and unreasonable and liable for interference. Ms. Ekayan, the learned counsel appearing on behalf of the respondents, on the other hand, submitted that the petitioners very well knew that there was a requirement of submission of the Annexure 5 as it is the mandate of Note Roman 2 for submission of the Annexure Roman 5. And it is also mentioned that failure to submit the Annexure 5 in the proper format would lead to summary rejection of the tender. The learned counsel appearing on behalf of the respondents further submitted that taking into account that this court is exercising the jurisdiction of, is exercising powers of judicial review, the same as per the settled principles of law is only to test the decision-making process. And if it is found that the decision-making process do not suffer from any vice of arbitrariness or unfairness or unreasonableness, this court may not like to interfere with the impugned decision taken by railway authorities to disqualify the petitioner's technical bid. The learned counsel further submitted that by tampering or modifying the Annexure 5, a vital aspect have been sought to be modified or tempered, which would affect the respondent authorities to take steps against the petitioner if there is non-compliance or breach to the terms of the contract. The learned counsel therefore submitted that this court may not interfere with the impugned decision, analysis and decision. Upon perusal of the materials on record and taking into account the submissions made by the learned counsels appearing on behalf of the parties, the point for consideration which arises is, number one, whether whether the respondent authorities were justified in rejecting the bid of the techno-commercial bid of the petitioner on the grounds stated in the email dated 22/9/2025. Question mark. Next. In the tender notice dated 12/6/2025, the note appended thereto reads as under Roman 1, Roman 2, Roman 3, page 25 of the huh? From the above note, more particularly at serial number Roman 2, it is stipulated that the tenderers are compulsorily required to submit a certificate as per Annexure 5 of the tender document. And without the offer, and without that, the offer would be considered incomplete and will be summarily rejected. Note Roman 3 further stipulates that in case the tenderer is a partnership firm, oblique joint venture, oblique Hindu undivided family, oblique limited liability partnership, etc., they are required to submit a further enclosure, that is Annexure Roman 5A, which has to be signed by themselves or through the attorney or the authorized signatory of the individual firms. From the materials on record, more particularly Annexure 1 Annexure Annexure 1 of the affidavit in opposition filed by the respondents, it would be seen that both the partners of the petitioner firm, that is Sri Babul Nath and Sri Sarmishta Nath, Srimati Sarmishta Nath, had submitted Annexure Roman 5, the certificate in Annexure Roman 5, along with the bid. Taking into account the reasons to assign it is further pertinent to mention that Annexure 2 to the affidavit filed by the respondent is the format for certificate to be submitted / uploaded by the tenderer along with the tender document. Taking into account that the issue involved is alteration of paragraph 8 of the certificate in Annexure 5, Roman 5. This court finds it relevant to provide the following chart to incorporate finds it relevant to set out the difference between the paragraph submitted by the petitioners, the partners of the petitioner. Number 1, in their certificate in Annexure Roman 5, more particularly paragraph number 8, with the format of the certificate in Annexure Roman 5, the same is provided in the following chart. Page 9, not sabo, or second. Hard to know. From the above chart, it will be seen that the partners of the petitioner firm in their certificates submitted as per Annexure Roman 5 have failed to incorporate the words which have been highlighted in the chart, that is, inverted comma, and may also lead to any other action provided in the contract, inverted comma, contract. And further, also included what he submitted is without this forfeiture of the bid security. Besides, have failed to incorporate it or incorrect to have failed to incorporate the words and may also lead to any other action provided in the contract, inverted comma. And have also inserted the words or incorrect. The above. Therefore, the certificate so submitted by the partners of the petitioner firm in Annexure Roman 5 is a modified certificate to that what the respondent authorities have sought for. Or in other words, it amounts to non-submission of the certificate as required under an Annexure Roman 5, as the certificate in question so submitted is not in accordance with the format so provided. At this stage, this court further finds it relevant to take note of the submissions made by the learned senior counsel appearing on behalf of the petitioner, that there is no requirement of submission of the physical copy of Annexure Roman 5. In view of the circular of the Railway Board dated 14/5/2024. In the opinion of this court, the petitioner herein cannot be allowed to raise the said issue for two reasons. First, note Roman 2 of the notice inviting tender dated 12/6/2025 is not a subject matter of challenge. Secondly, the petitioner having already submitted the annexure certificate under Roman 5 as per Annexure Roman 5 cannot, now having found that its certificate was not in accordance with the format, take up the plea that the certificate was not at all required to be submitted. Accordingly, this court therefore do not find any ground to interfere with. Accordingly, this court does not find that the actions on the part of the respondent authorities to reject the techno-commercial bid of the petitioner to be unfair or unreasonable or violate the mandate of Article 14 of the Constitution. Conclusion: the writ petition lacks merit. Accordingly, writ petition stands dismissed. However, in the facts of the instant case, this court is not inclined to impose costs.
Alright, this one item 18.
Can get changed in order whereby the get in non-performance. The contract tonight. Because of school property, the work initially the work was primarily developer, the completed about 90% of the work. Whereas in people for declaring non-performance, because lot will be fine. It be 130 rupees.
Where's the impugn order?
You can already the pay. 156. 156. Just 2 lines without considering our detailed reply to your survey.
What is the stand of the respondents?
They are not finally replied.
Where is the show cause notice?
Because notice is was finally page 130.
Where is your reply?
My reply is at page 136.
And the result is this.
Here.
Yes, Mr. Sakya.
But the entire issue whether this Rohan has circular. Actually, find that circular on the page 158.
SOP.
Up to page 168. Paragraph 5.
There are 4 or 5.
Paragraph 5. Page 1.
Now, there's no quarrel with that. But you have given a long show cause notice. He has also given a reply. Are you not therefore required to assign reasons?
Yes, the reasons are there. Can you come to the page 45 of side in opposition?
No. The reasons are not here in the affidavit. The reasons are to be given out there in your order. Where are the reasons? You see, the matter has been pending out here for the last, no, Mr. Sekhya, kindly appreciate one thing. Matter has been pending out here for the last 3 years. The question therefore is, there is a stay also operating. The best option is to interfere and give you and pass a reasoned order.
In fact, also look into the order that we see 2055. We have, on instruction, we have submitted that, we have committed withdraw and we issue a case. He did not agree, he wanted to have a hearing on merits, so the matter has been.
His hearing on merits is the final outcome is that only.
That only looks typically look into the.
You don't withdraw. You withdraw means we set aside that. And you give a fresh, if he seeks for a personal hearing, do you want a personal hearing? And hearing and give an order. Matter of.
Or actually, As per it, my lord, what I'm saying, as per the procedure, whatever the reply he has submitted.
No more reply. Reply over. Stage is over. You give him a chance of hearing if he wants. And then pass an order, give a reason.
Let us have a long and we have.
The long back also, you see, the matter never came up before me.
The offer was slightly different, that's why I objected. Otherwise, this kind of order, even I take that this is the order.
Everything reflected
Because
in the order.
it has a consequence measure, my landfill is read paragraph 5. At one page 169, paragraph 8 is the consequence of this declaration of non-conformance. Upon declaration of non-conformance, regard.
No, that's okay. That is the consequence. I also understand, you also understand, Mutiji. So therefore, the reason has to be given. In fact, in a recent judgment of the Supreme Court in that Oasis, the Supreme Court also observed that it is not, the court may interfere and direct the authority to again reassess. That's the only scope we have. Chalo. Heard Mr. D. Mojumdar, the learned senior.
Possibly, you know, the direct hearing. The remaining part of the work is more or less 10% was given to some other part. And our agreement was not actively terminated. Earlier they issued, then subsequently there was a hearing notice. But thereafter we challenged it and we withdrew the petition. Then my lord, the remaining part of the work was given to another contractor, they have completed. Now their work has been suspended, we have been brought back to maintain, so we are maintaining for them, for the care.
That's a different thing. I'm not on that. I'm not going to look into. I'm only looking into this order. Heard Mr. D. Mojumdar, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioner. Mr. P.J. Saikia, the learned senior counsel, assisted by Mr. R.K. Talukdar, appears on behalf of the NHIDCL. The present petition has been filed by the petitioner challenging the order dated 4/5/2000, communication dated 4/5/2022, issued by the Deputy General Manager (P) of the NHIDCL, whereby the petitioner was intimated that he had been declared that its firm. Whereby the petitioner firm was declared as a non-performer. The dispute involved in the instant proceeding is on a very small issue as to whether the respondent's authorities were justified in declaring the petitioner as a non-performer without assigning any reasons. It is seen that the respondent authorities have issued a show cause notice on 14/3/2022, thereby alleging various deficiencies in the work of the petitioner. And the petitioner was therefore asked to submit explanation within 15 days from the date of the notice as to why the petitioner's firm be declared as a non-performer. Why not the petitioner firm be declared as a non-performer in view of the provisions stipulated in the circular dated 6/10/2021 and the provisions of the EPC contract agreement. The petitioner, on receipt of the said show cause notice, submitted a detailed reply on 29/3/2022. Full stop. Was there any hearing given? It is also alleged that there was no personal hearing given to the petitioner. That is why I'm saying it's alleged. Pursuant to the reply so submitted on 4/5/2022, the impugned communication was issued, whereby the petitioner was declared to be a non-performer. Taking into account the relevance, the contents of the communication dated 4/5/2022 is reproduced herein under page 156. A number of Pradibo RO pra Tolothol DY General Manager bracket P, page 156 of the same. The petitioner, being aggrieved by the communication dated 4/5/2022, has approached this court by filing the present petition. The record reveals that by the detailed order dated 25/5/2022, the Lalit Coordinate Bench of this court, taking into account that the impugned order communication dated 4/5/2022 was without assigning reasons, have stayed the communication dated 4/5/2022. The interim order thereupon have continued from time to time. The record further reveals that the respondents have duly filed their affidavit in opposition justifying their stand. For issuance of the communication dated 4/5/2022. Taking into account the order which this court proposes to pass, this court would not like to go in detail as regards the justification, taking into account that the order which was passed, taking into account that the impugned communication did not contain any reasons. This court duly heard the learned counsels appearing on behalf of the parties whose submissions have been taking into account the pleadings contained in the petition in the submissions were in tune with the pleadings, respective pleadings. This court, upon hearing the learned counsels appearing on behalf of the petitioner, on behalf of the parties, and taking into account the show cause notice, the replies were submitted by the petitioner, and the impugned communication dated 4/5/2022, it is the opinion of this court that the order dated 4/5/2022 do not contain the reasons, merely referring to a circular dated 4/6/10/2000, circular dated 6/10/21 cannot be a reason, cannot be reference to a circular dated 6/10/2021 cannot be regarded as a substitute for the purpose of assigning due reasons. More particularly, taking into account the consequences which would befall upon the noticee if declared to be a non-performer. Next. This court also duly takes note of that in the affidavit in opposition filed by the respondents, the respondent have tried to justify their stand, justify the impugned communication dated 4/5/2022 by providing due reasons.
By the filing of the authority. By filing of the authority on consideration of the.
Due reasons. It is a well-settled principle of law that administrative orders must be read in the light of the concomitant records. Now, it is a well-settled principle of law that administrative orders are required to be tested on the reasons so assigned. It is also no longer res intriga. The reasons need not be stated in verbatim in the communication, so long they can be discerned from the file and are not post justifications. In other words, what is permissible is elucidation of contemporaneous reasoning already traceable on the record. And what is impermissible is the invention of fresh grounds to retrospectively justify an otherwise unreasoned order. In the instant case, there is no reasons assigned except reference to the circular dated 6/10/2021 and that the respondent authorities have taken that the said decision has been taken with the approval of the competent authority.
The reasons are under that page 45 of the affidavit. The finding of the authority, that's the reason. So that reason must be placed for the authority. They have.
Did you provide that order to him? Did you provide him that order?
That order was not provided,
That is what, no, you should have provided him that order.
but not a phrase reason what we are trying.
I'm not saying that, no. See, what is permissible is this, but what you have done out here is, there's no reason at all. You can improve your reasons. You may not say verbatim whatever the reasons, but what you cannot do is to bring in account some reasons by way of an affidavit. That is what I'm saying.
My intention, the reason is the record, which we have communicated by way of this affidavit.
Then you are not giving him the order.
At least, by way of the affidavit. that-
You cannot do that. That you cannot do that.
I have to justify the reasons
No.
by the record.
Okay.
In the instance case, there is no reason assigned.
There is no reasons assigned in the impugned communication dated 6/4/2022. What is mentioned is, as regards the circular dated 6/10/2021. And further, that the same communication has been issued with the approval of the competent authority. Considering the above, the course therefore open to this court is to first, therefore, to cancel the considering the above. At this stage, this court finds it very pertinent to take note of a recent judgment of the Supreme Court in the case of State of Himachal Pradesh and another versus Oasis Cybernetics Private Limited, OASYS, all caps, Cybernetics, C to Dhamma, Y, Cybernetics Private Limited, reported in 2025 SCC Online SC 2536, wherein the Supreme Court observed that what course of action should be taken in such situation. Paragraph 31 of the said order judgment being relevant is reproduced hereunder. Taking into account the above proposition, this court therefore disposes of the instant writ petition with the following observations and directions. Number one, the impugned communication dated 4/5/2022 is set aside and quashed. Number two, the respondent authority, this court remits the matter back to the competent authority to reconsider the question upon recording cogent reasons and affording due opportunity to the petitioner. Remits the matter to the competent authority to reconsider the question as to whether the petitioner hearing can be declared to be a non-performer. And upon carrying out the said exercise, the competent authority shall decide the said aspect by recording cogent reasons. Number three, taking into account paragraph number 5 of the circular dated 6/10/2021, this court gives a liberty to the petitioner to request the competent authority for a hearing, personal hearing. And it is observed, and this liberty is for a period of 15 days from the date of the present order. It is observed that if the petitioner exercises this liberty, exercises in consequence to this liberty, the competent authority shall provide the petitioner an opportunity of personal hearing. Number 4. So they go to number 2 it remits the matter the respondent competent authority while deciding the dispute, the question as to whether the petitioner is to be declared as a non-performer or not shall provide due reasons. Provide cogent reasons. Shall record cogent reasons. Anything more? The interim order pass. Oh no, we have already set aside, so nothing.
Item 19 and 20. certain legislative which have.
Yes, last time I asked you, what power who has? What was the power, what was madam, I asked something, this was some power was the issue, huh? They didn't have the authority.
Yes.
The labor commissioner or somebody did something. Ah,
So they filed a petition for promoting, then they filed an application of something. And he filed it to himself, he checked it. He decided the matter himself.
no, but I said that he even doesn't have the authority to do that.
Authority to that, it is handled
Does he have the authority?
on process.
Does he have the authority, the labor commissioner? Huh? I also think so.
There's no authority.
It is by the labor court.
No, he did not decide. He had a conciliation. He had held a conciliation. And in the conciliation, he said X amount has to be paid to the work, which we take that. But another issue was raised that the workman has to be retrenched. That issue, he did not agree. He did not even file a failure report before the court, for the government. So that the government that's the president for deciding the dispute. If any provider, I am an industry also, because that is also a question mark. Because this industry.
No, he also decided on the question of retrenchment.
That he did not decide. He did not frame any issue on the procedure. He only talked about even though.
What is the decision? Let us see what you are challenging.
Because I am, in mind, there's a second thing. I am challenging the order passed by me that is at
Page,
page 51, 52, and actually, that is the order I am challenging.
between so and so and so and so, peruse the application filed by the applicant, which is stated that the opposite parties willingly failed to make payment of the monthly earned wages to the employed, violating the provisions of section 3A of the payment, and even the opposite party have deliberately failed to implement the settlement arrived at through the consultation held. Give me the payment of wages act. So he has the power. The State Labor Commissioner has the power under 15(1). But the question is, if you see the compensation as per 15(3), where any application under subsection 2 is entertained, the authority shall hear the applicant and the employer or other persons responsible for payment of the wages under section 3, or give them an opportunity of being heard. And after such further hearing, if any, as may be necessary, may, without prejudice to any other penalty to which such employer or a person is liable under this act. So this is without prejudice. So this penalty can go divorce the other proceedings. These proceedings. Amount, direct refund of the employed person of the amount deducted or the payment of the delayed wages, means he can direct for payment of 8,92,029,000. There's no quarrel. No. Together with payment of such compensation as the authorities may think fit, not exceeding 10 times the amount deducted in the former case. Means deducted.
If I deducted 7,
If you have deducted certain amount, then,
10,
but not delayed.
not 10. In case of
Deducted in the former case, and not exceeding 3,000 so and so, but not less than 1,000 in the later, means the compensation cannot be 10 times. On that, it can be at best
3,000.
3,000 rupees. And even if the amount deducted or delayed wages are paid before the disposal of the direct payment of such compensation as they think not exceeding 2,000 rupees.
Yes.
So if there is a delay or anything, so the question of payment of 10 times does not arise.
Does not have.
That's your case.
And not say, Assistant Labor Commissioner
Have you paid that 8,29,000 or not?
tender, because as per me, he was retrenched in 2016. And I tendered the entire amount which he refused to accept. That's on record, he accepted that I refused to accept. And then he said that you cannot retrench.
But who has decided the retrenchment?
Retrenchment has not, that has never been an issue. That has never been an issue.
So your case is that he has been retrenched.
My case is that he is not been retrenched.
So how did you retrench him?
What had happened, Dr. MO was taken over by Wimco, some manufacturing company. And after that, Wimco was running the manufacturing company. And in 1997, after the ban order by the Supreme Court on all forest related activities, Wimco closed down. We, ITC, had merger with Wimco. And the non-engineering assets of Wipro came in the share of IT. But those of the Calcutta High Court and Bombay High Court order in company, separate company. That's how he came to it. He stepped into this.
But
Wipro.
if you have retrenched him,
Yes.
then where is the question of delayed payment?
No delay payment up to that point, in the point of retrenchment.
When did you retrench?
16.
Huh?
2016.
No, here the monthly wages is from 1/1/2016 to 31/5/2022.
The Labor Commissioner, Assistant Labor Commissioner held that he still continues in service when there's no work, because what had happened when we took over Wimco, we had 11 securities staff. Wimco had 11 security staff, temporary security staff. We handed over the security services to Omega Security Services Limited with the option to the security staff to join Omega, and Omega was willing to say, out of 11, 10 accepted the services. The 11, that is the person Christian, did not question the respondent here. That's why, Lordship, we made the payment. And then there was a conciliation. And he kept on paying me. He did no job afterwards whatsoever.
When there was a dispute, there was conciliation.
But are you challenging this conciliation order? Minutes of the conciliation order dated 6/2/2017. If you are not challenging, in the minutes of the conciliation order, it is categorically mentioned that you have raised the issue of retrenchment and you have given up. Kindly come to page 33 of his writ petition. Page 33 of his writ petition. Last portion. And the complainant Monwar Hussain and so and advocates as well for the complainant. In the part conciliation meeting held on so, the management averred that Monwar Hussain has been retrenched
Yes.
from service and he is not entitled to anything except retrenchment benefit.
Correct.
But the management failed to produce any valid document in connection with the retrenchment of Monwar Hussain and proof of compliance of the prescribed procedure of so and so. In fact, the management just sent a letter dated so and so to the authority stating that the complainant was retrenched from Iman, which is not in accordance with law. Hence, the plea of retrenchment of so and so was rejected, and this issue was given up. During the discussion, it is found that the authority, that is Monwar, has been performing his duties as a security guard, but his monthly has been held up. The management has then prayed for some time to discuss the matter with higher authorities regarding payment of the salary. The complainant so and so also did not raise any objection regarding grant of time to the management. So the final phase of the conciliation meeting is held up today over the only issue of non-payment of the due salary. After threadbare discussion, the areas of the so and so will be paid by him by the management within 1 month. The area salary is so and so. So this happened in the year 2017. So under such circumstances, you cannot raise the issue of it, he has been retrenched.
So also they have to be paid the salary, which we refuse to accept.
Hmm?
We paid the salary, which we refuse to accept.
But anyway, his salary is this 8,29,000.
Since 2022.
It's okay, pay that.
We did that. That will be.
And apart from the 3,000, not this.
Okay, in fact, if I may take my lord to section 17 of the act.
Huh?
Section 17 of the act. The reason why they have come up with this particular petition, just to evade section 17 of the act.
What is that?
That is an appellate provision, my lord, where they need to submit the entire amount which has been passed.
But if the,
17(1)(a).
but if that amount is wrong,
This is the appellate provision.
This type of submissions does
And
not.
my lord, there is a limitation period also of 30 days if they want to challenge this particular order.
Which order?
This order, my lord, which has been passed.
I am sitting aside on the absolute wrong application of law.
57.
I am not sitting aside on that. You are entitled to this amount, 8 lakh so and so, plus another 3,000, whatever may be. And also during this period also no retrenchment done. You will be entitled for this salary also. Or should I keep this matter asking them to make the payment and then see of his?
Congress paid, my lord.
Better off. Good. You make the payment within 1 month. ITC, very big company.
not this one, I'll pay 8 lakhs. 8 lakhs I'll pay.
No, 8,29,000 you pay,
Yes.
and then we pass the order till 2026 later on, next year. Because you have not retrenched. Unless you take up steps for retrenchment, this court is not going to do that. So you pay this. But as I tell you, the 88 lakhs is wrong. This is not happening. So you pay 8,29,000 plus 3,000.
Lordship, the question of no work will come in.
What?
It's not done any work.
What?
It's not been working.
You have duly admitted that he is working out there as a security employee.
No. After 16 years, not been working. Omega Security Services is working. It's not working after.
No, here this is a direction which has been paid. Then where is your thing that is regard that?
No, this direction.
Okay, then remaining we won't look into now. You first pay that. We'll look into it later on. Let better senses prevail in 2026.
Exactly.
8,29,000 plus 3,000. You pay that, we'll see. Okay, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner in WBC number 4965/2023. And Mrs. M. Hazarika, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioner in WBC number 5398/2023. The counsel who represents the petitioner in WPC number 4965/2023 represents the private respondent in WPC number 5398/2023. And the counsels who represents the petitioner in WPC number 5398/2023 represents the private respondent in WPC number 4965/2023. Mr. K. Gogoi appears on behalf of the state of Assam. Both the petitions are interconnected. It is relevant to take note of that the petitioner in WPC number 4965/2023 was earlier employed in a company in the name and style of Winco. Limited, which pursuant to a scheme of arrangement was taken over by the petitioner in WPC number 5398/2023, isn't it? Certain disputes arose as regards non-payment of the dues of the petitioner in this petitioner of WPC number 4965/2023. Pursuant to the said disputes, a conciliation proceedings was initiated wherein both the petitioner in WPC number 4965/2023 as well as the representative of the petitioner in WPC number 5398/2023 were duly represented. Were duly present. In the said conciliation proceedings, the petitioner in WPC, the representative of the petitioner in WPC number 5398/2023 raised an issue that the petitioner in WPC number so-and-so 4965/2023 was retrenched with effect from 1/1/2016. However, taking into account that there was no materials placed, it is recorded in the minutes of the conciliation meeting held on 6/2/2017 that the representatives of the petitioner in WPC number 5398/2023 had given up the claim that the petitioner in WPC number 4965/2023 was retrenched. The only issue, therefore, which arose on that day to be decided in the said conciliation proceeding is as regards payment of the arrears of salary. It was decided in the said minutes of the meeting held on 6/2/2017 that the area salaries would be paid to the petitioner in WPC number 4965/2023 within a period of 1 month. By the management of the petitioner in WPC number 5398/2023. Next. It so happened that the management of the petitioner in WPC number 5398/2023 did not make payment.
It's on record.
It so happened that that disputes arose as regards the payment to be made, as to whether payments were made to the petitioner in WPC number 4965/2023 by the management of the petitioner in WPC number 5398/2023. Inasmuch as Ms. M. Hazarika, the learned senior counsel appearing on behalf of the petitioner in WPC number 5398/2023 submits that the petitioner in that the management that her client had duly offered the said amount, which the petitioner in WPC number 4965/2023 has refused. Be it as it may, in view of the disputes, an application was filed for payment of the arrears salaries with effect from January 2016 to 31/5/2022. The learned additional commissioner cum authority under the Payment of Wages Act 1936, who is the respondent number 3 in WPC number 5398/2023, passed an order on 15/7/2022, thereby directing the petitioner in WPC number 5398/2023 to pay an amount of rupees 82,98,330 within 15 days from the date of the issuance of the said order, failing which proceedings would be initiated under the provisions of the Bengal Public Recovery Act, the Public Demand Recovery Act 1913. It is under such circumstances, WPC number 5398/2023 was filed before this court. And this court, by an order dated 18/9/2023, had stayed the order dated 15/7/2022 and all other consequential proceedings. And the said interim order continues from time to time. It is also relevant to take note of that WPC number 4965/2023 was filed by the petitioner seeking enforcement of the order dated 15/7/2022, which is impugned in WPC number 5398. This court duly heard the learned counsels appearing on behalf of the parties on the legality and validity of the order dated 15/7/2022. The counsel for the petitioner in WPC number 4965/2023, Mr. So and so, duly submitted that the said that orders so passed by 15/7/2022 do not require any interference, taking into account that it has been passed in accordance with the provisions of Section 15 of the Payment of Wages Act 1936. The Learned Counsel further submitted that instead of that the petitioner in WPC number 53 so and so ought not to have approached this court, taking into account that there was an appellate provision provided and there was a remedy provided, an appellate, that an efficacious and alternative and efficacious remedy provided in terms with Section 17 of the Act of 1936. The Learned Counsel also submitted that in order to bypass the requirement of depositing 100% dues, 100% of the assessed amount, the petitioner have approached this court by filing the writ petition. And under such circumstances, WPC number so and so ought to be dismissed. By contra, Mrs. M. Hazarika, the Learned Senior Counsel, appearing on behalf of the petitioner, submitted that the facts in the instant case are duly admitted. What is required is the application of facts to the law, more particularly in respect to as to whether Section 15(3), what is the mandate of Section 15(3) of the Act of 1936? Referring to the judgment of the Supreme Court in the case of Godrej Sorely Limited versus so and so, the Learned Senior Counsel submitted that when the facts are duly admitted, facts need not be probed into, and what is required is an application of law, the law. The question of remitting the matter to the statutory authorities ought not to be carried out, ought not to be done by the court while exercising the jurisdiction under Article 2 to 6 of the Constitution. The Learned Senior Counsel further submitted that a perusal of Section 15(3) would categorically show that what is the compensation that can at best be imposed upon if there is a delay in making payment. Taking into account the instant proceedings relates to delay in payment and not a case coming within the ambit of deduction of any payment, deduction of any amount. The Learned Senior Counsel submitted that the maximum compensation can be rupees 3,000 and the minimum to be rupees 1,500 and not more than that. The Learned Senior Counsel, drawing the reference to the order dated 15/7/2022, submitted that the respondent number 3, for no reason, contrary to Section 15(3), had imposed a penalty 10 times the amount which the petitioner as penalty 10 times the amount assessed as delayed wages with effect from 1/1/2016 to 31/5/2022. Which is not permissible as per the Act of 1956 to 36. Further to that, the penalty provisions as mentioned as stipulated in section 20 of the Act of 1936 can only be tried by court and not by the respondent number 3. By the assistant, what it is? Additional or what? Additional? Huh? Assistant, additional. Anything more, madam?
Application filed by team.
It's okay. Anything more? No, but this amount you are entitled. Not this 10%. 10 times I'm striking off now only.
That's, that's the role of the company. So that is.
That I will look into it. Wait, first, let me set aside this for the time being. You pay, we see the compliance report, then we see. Because what happens sometimes after doing it, all this exercise, if I keep it and later on, you don't feel like again doing the same matter again and again. It feels very boring. This court, having heard the learned counsels appearing on behalf of the parties, the point for consideration which arises is as to whether arises in both the writ petitions is as to whether the learned respondent number 3, as to whether the learned the Assistant Labour Commissioner Dhubri was justified in passing the impugned order dated 15/7/2022. The fact, upon hearing the learned counsels appearing on behalf of the parties, there is no issue as to the quantum payable on account of the delayed wages with effect from 1/1/2016 to 31/5/2022. What is being assailed in the order dated 15/7/2022 is the imposition of penalty of 10 times of the delayed wages to the tune of rupees 82,95,330. In that regard, this court finds it pertinent to take note of section 15(3) of the Act of 1936, which being relevant is reproduced hereinunder. Perusal of the above quoted provision reveals that the authority as notified by the appropriate government in terms with section 15(1) of the Act of 1936 have been authorized to entertain applications filed under subsection 2 of section 15 of the Act of 1936. And after giving a hearing to the employer or other person responsible for payment of wages under the section 3 of the Act of 1936, have been empowered to pass the following orders. Number one, direct refund to the employed person of the amount deducted or payment of the delayed wages. Number two, payment of compensation The payment of compensation is also segregated into two portions, two parts. One pertains to deduction of the amount, and the other pertains to payment of delayed wages. In the case of deduction of the amount, compensation can be directed to be paid not exceeding 10 times the amount deducted. And in the case of delayed payment of wages, the compensation cannot exceed rupees 3,000. But cannot be less than 1,500. It is further stipulated in subsection 3 of section 15 that this direction, this adjudication should so directed to be carried out. Carried out is without prejudice to any other penalty to which the employer or other person is liable under the Act. In the backdrop of the above, if this court now takes up the order dated 15/7/2022, it would be seen that on account of the delayed payment of wages with effect from 1/1/2016 to 31/5/2022, an amount of rupees 8,29,533 have been determined. In addition to that, compensation has been directed to be paid to the tune of rupees 3,000. Next. It, however, surprises this court as to how the penalty to the tune of 10 times of the delayed earned wages would have been imposed by the respondent, by the assistant Labour Commission, taking into account that the imposition of penalty is stipulated in section 20 of the Act of 1936. and the power to try offences in respect to such penalty is conferred upon the court and not the assistant public. So and so. Considering the above, this court therefore is of the opinion that the imposition of penalty by the respondent in the impugned order dated 15/7/2022 was contrary to section 15(3) of the Act of 1936, or for that matter, the provisions of the Act of 1936. Next. This being the above, it is therefore the opinion, further opinion of this court, that as the instant matter pertains to wrong application of the provisions of law in view of the judgment of the Supreme Court in the case of Godrej Farali, Supra, this court, it would not be proper on the part of this court to remit the matter to the statutory authorities. Accordingly, this court, therefore, passes the following directions.
Manoj Hussein's case, that is 49665, it needs more representation. To the principal secretary, page 1. He specifically says that IPC Group D sent the a letter dated 31/3/2017 under caption order of replacement on 31/3/2017, and on that and the demand of the school land 23,000 and 60 account as petitioners area monthly wages and replacement compensation, etc. So as to compensate the petition to accept the replacement of letter and compensation while accepting the area wages. So this retention letter was sent, but we don't have a copy of that. This retention letter was sent after the conciliation order.
Okay, no problem. It passes the following directions. The petitioner in so and so is directed in 5/6 is directed to deposit the amount of rupees 8,29,533 plus 3,000 before the registry of this court on or before 19th of January 2026. Upon such deposit, the petitioner in WPC number 4945/2023 is given the liberty to file an application before the registry for release of the said amount. And the registry, upon carrying out the necessary verification, transfer the said amount, disperse the said amount to the petitioner in WPC number 4964/2023. to the petitioner insurance. First, list this matter again on 10th of February 2026 for an update. Absolutely no. Then I do one thing. No, let me do one thing. You want to say that, na? Okay. No, we imply section 17. No, I dismiss it on the ground. Don't come up with that. Hey, to this you are getting a relief of 88 floods. That is. After that, Mr. Counsel, after getting that, where's the counsel? After getting that amount, you withdraw your petition and the matter has been. Yes, where is Mr. Zial Pasha? Petition after petition. What is this review petition for? What review? Huh? Oh, this one. No, I have disposed of. Oh, yes. What is this? Again, another problem. Huh?
Was entitled for this method, certificate. The witness next method was statement. That will look at page 47.
I think we should ban Mr. S. Hope coming into with these figures. Last 6 petitions I have dismissed.
27, page 27.
Like 6 site verification certificate I have dismissed.
Approximately page 27, that is the case.
Page
27
of the writ petition.
of the
7.
case number 1 for detail of the fighting.
Ah,
Here, what we will see, my lord, in this particular case, there are 65 sites.
how many?
65 sites. All works, my lord, in 65 locations. It continues to page 30. We have given my lord photograph of 4. So if all other witnesses, my lord, they have given 65, my lord, from 65 exact sites. That's the reason, in fact, my lord, reminder was given, what we will see the repetition. We informed him, my lord, that you give the precise photographs from the precise locations. Page, my lord, we will see 170. Opportunity was given. Under the page 170, second para. It is
170?
170. Second para.
170 is my order.
Well, before that, then, in the place before that, page 1.
Requirement of complete documentary evidence.
Yes, it is mandatory.
169A.
Yes, 163.
He has given only 4 photographs.
Second para is very clear, my lord. Photograph of all relevant sites and other related documents. He again, my lord,
It is mandatory to furnish complete and adequate documentary, including photographs of all relevant sites and other document purposes. Yeah?
this is the expression.
Now, my lord, photographs are some photographs.
You should have given pause in 63 poses and given 63 photographs.
Don't know, my lord, how they are expressing it, my lord. Moreover, what I am, my lord, in that close 7 on, my lord, there is no specific provision, my lord, for copying the photograph. Even, my lord, I have annexed some at least, but there was no such provision. Provisions also, my lord, they executed or they have prepared some part of photograph. On the record, my lord, is
Instead of over, tell me one thing. Has the other bidder submitted 63 photographs?
Yes, 65. The specific query should have given in, he said all are given. And my lord, accordingly, whoever has been issued, they have given. The 65 minus small works, my lord, in the various locations. That they have given. That's my specific query and lost my recording. That's why she said, my lord, all relevant sites. The reminder that was given to the petitioner, that we furnish again, all relevant sites.
By that time, very late, they Yes, was withdrawn by the High Court matter. Immediately I had informed him the site. Yet, the site matter on same day matter. There is matter, part more matter. Some one matter, little more matter, or so, or percent more matter, but like this very small matter. He did not choose the place matter. He chose the bigger one, bigger work matter.
We do one thing, let us see others have given 63 photographs on. If others have given 63 photographs,
Yes.
good. If they have not given, all are disqualified. Win-win for you. Isn't it?
Matter.
Well, in my instruction, last year I think very clear. They, given the last year, it may be mentioned here that the site visit certificates were issued to the other bidders, as they had duly submitted photographs of all the 66 numbers of site location included in the package number 140. Very clear.
As per clause 7 on matter, the requirement of photographer, that was never incorporated in clause 7.
Then why did you give photographs?
Well, from what the case, well, what I stated, Malakali on the interesting people, based on what it is on what ballot, this had been certificate are the same activity in a ballot. Even this certificate ballot, the petitioner never submitted a single photograph. They have visited, they have submitted certificate, they have discovered. Now, from where they have inherited that provision or photograph, taking photograph. Can they show that again this at this certificate, they can show a single photograph, well, tax review, they have no mind. Based on it, it one now.
Like when they are orders of the honorable court, now their geotech certificate will have to be submitted.
Huh?
Geotech certificate will have to be submitted. Well, here they appeared in several repetitions.
Geotech for that, that's why
We have considered.
I where for that postman. Provision, close 7.1 million, I have disputed it, there is no provision, that is the only the undertaking the risk file. There is no such provision of taking geotech photograph. Only the condition was that you visit the site, you take the responsibility, you cannot keep them. Only that part of it, they are understanding is our risk file. And now from that what they are playing this 7.1 million, only to people from Malad party. They choose their, this is a criteria, my lord. Now if I even qualify, my lord, they will disqualify in a technical bid, my lord. Basically, they are financial bid, because they have some shortage, my lord, contractors, my lord, they will choose their. 182, my lord, 142 package, same thing happened, my lord, that are cancelled twice. Because they have taken some contractor particular matter, only they are allowed to work. Even if qualify financial bid also matter, they will pay matter. This is the thing happening there, the ground position. And theater photograph matter, they have not been comporting any close matter. Where they SOP matter for the aspect of 7 or matter. Is there any detailed instruction? Nothing matter.
But if they are not there in the meeting, there is such allegation.
No.
We cannot.
And
claim
seven, I am,
That is not the key here.
no,
We
I am
should let
Seven
us.
point one, I have, that big document I have annexed. 7.1 is there, but 7.1 is there, but let me show where it takes photo, JPEG photograph. Is there any provision for taking JPEG photograph? Nothing, well, in the big document.
I passed an interim order.
No, the technical regulation is going on. That's in fact, around for a stage and melon, before the last date of submission of this particular interim order on the last page, if it is open, then probably melon case cannot be considered, because relatively fast, the interim will go late. Last date was in September 25.
No, then give me a detail as regards, put it on this on affidavit, he can file his reply. We'll see when the matter is
Right.
taken up, or give him a certificate.
Certificate may have gone.
He gives an undertaking. Why do you need the site visit certificate?
Yes.
Only reason for your site visit certificate is that look here, this particular thing we require. Tomorrow, the person concerned cannot say that the site was bad.
On that.
That's the reason why. You don't give it for other purpose.
But ma'am, that man will have to be put to challenge, because by this letter is 1
in an A, we have categorically stated you furnish photographs. You'll have to challenge that part, madam, that's
That is
material submission. You are
Yeah,
not aware, madam.
that is just communication, madam.
What
Somebody
something communication, it's not,
That's the communication.
what you have expressed, you'll have to follow, make a specific selection. And that will be applicable not in this particular case, in every case in that case from now. The honorable court decides. If the honorable court decides that madam, geotech photograph will not be necessary, yeah. You have to.
No, geotech, because your clause does not say geotech.
Yes. Well,
Your clause does not say a
you
geotech.
can't- you will have
It
to-
does not even say about photograph.
Even then, my lord, lieutenant, my lord, he has visited there, upon satisfaction, there is a clause finished, man. Clause you will see, my lord, clause 7.1. Page 47.
Act says, madam, act. Complete the certificate, madam, in the format that I visited the site. That's enough, madam.
Okay, you do one thing,
Anything advance
you
happened,
file this by way of an affidavit, let him file it.
Yes.
We'll see when the matter reaches. In time order to you enjoying. Otherwise, give, in the meantime, if you give a geotech certificate, you, sites visit certificate, if he gives you, then you withdraw.
Then, my lord, we proceed.
I've never asked you not to proceed. I've asked you to proceed. Only thing is, you cannot reject on the basis of 7.1.
If on the day of passing of the intelligence on the technical review was not open, that's a very clear.
Yes.
But,
So, no, as of now, it has not been opened.
no, it's under consideration, open, we are verifying the technical.
So therefore, it's not closed, so therefore,
And then for this one, different thing, madam.
no,
We have
no,
opened.
no. Okay, we make it very clear that we shall not reject it. Should not be on the ground of, I make it very clear that the intermarriage, the caveat there is in respect of the year pertaining to the intermarriage. Over, I never said open. Technical evaluation is over. So consider
Then not, but then not, for that fix them, madam. I will find that for it.
after vacation, not now. You file within 10 days, he'll file another 15
In
days.
that case, madam, immediately under the open,
Huh?
immediately on the week of the open.
You file within in the reopening, he will file after that. Again, another
We will have to
second.
proceed, madam.
No, you are, go ahead. I've asked you not to only reject on 7.1.
We cannot finalize it. So finally, we'll have to wait, madam. Again.
No.
Disposal.
For that, you give him the certificate.
Yeah, madam, we will
Madam,
not
if
give.
I know that is qualified, madam, what they are so, madam, I don't know, madam.
No, after the last date, it is not possible. That after the last date of submission of pay, the issuing of certificate. Unless when it's a finding of the honorable court that we have been illegally deprived from giving the certificate. There is no question of issuing the certificate.
Okay. We'll give that finding later on. First you file your affidavit.
Right.
Pursuant to the observation, pursuant to the order passed by this court on 27/11/2025, the respondent, Mr. B. Gogoi, the learned standing counsel of the PWD, has placed before this court a set of instructions wherein it is mentioned that the petitioner have not provided the documentary evidence of having visited all 66 numbers of site location, which falls within package number MAINT/G/2025-26/143. Whereas the other bidders have duly submitted photographs of all the 66 numbers of site locations. Full stop. It is the opinion of this court that the said aspect be brought on record by filing an affidavit so that the petitioner is in a position to file a reply. Full stop. List this matter on 7/1/2026. In the meantime, the affidavit be filed on behalf of the Interim order passed earlier shall continue. Till the next date. Chalo. Any more? Any more? Or anybody wants a date, take here the dates for me. Huh? If there is an interim order, the interim order would be extended subject to the date to be put. If there is an interim order, not a long date. But if there is no interim order, then you can take in the month of August also.